need your debit card. What about an insurance card?
I'm sorry, but this is not my brother. Because he was getting into an argument with his stupid girlfriend.
You know you're stepping on your glasses?
I do a little bit. I'm sorry, and I do apologize. If you want to give me a ticket, that's fine.
No, my main concern is that you're okay, first of all, which you haven't really answered. Two,
I'm okay.
I was just letting you know that you were standing on your glasses.
Okay. I'm okay.
Okay.
But it's just the fact that my brother's calling me like, oh, come and pick me up because my girlfriend's being a bitch. Who's not going to pick up the brother?
You called him your nephew earlier, so is it your brother or your nephew?
No, that's my nephew. I'm sorry. I'm a nurse.
So where did you pick him up from?
No, I meet him at the bar.
Okay. Did you have any drinks?
No, I really didn't. Like, oh God, no, I really didn't.
Well, what bar was it?
I can look it up. Give me 1 second.
You don't know where you just left?
It was my first time going there.
Okay.
It wasn't like, oh my gosh, something crazy that I would be like, oh my gosh, I'm crazy. I am a nurse.
You don't have to tell me that again. You've literally told me 25 times that you're a nurse.
I'm sorry about being honest with you.
I'm not saying that you're not being honest. I'm just saying you keep saying the same thing over and over and over again.
I'm being honest to you that I'm a nurse.
I appreciate your honesty.
There's nothing wrong with that.
Oh, we appreciate it. No, I appreciate your honesty and I appreciate your work.
I am honest. And I told my brother, yes, I'll go pick you up from there. Because why?
What's going on with your nephew?
He's talking. Oh, your friend doesn't like me anymore. This and that. I was like, that's what he's feeling.
That's what I was asking. I was asking, like, what's going on? He's like falling in and out of sleep over there. He's going to be okay.
I have nothing against me. I really don't. You know Steve Spar?
Steve Spar? Is that who you said?
Yeah.
I do.
He's really good friends with me. I don't think I have anything. No, I really am some honesty. I don't have anything again.
Well, because the airbag's deployed and he keeps kind of passing out and whatnot, the fire department's going to be on their way, okay? They're just going to... You think that your car is drivable right now?
You want me to be honest with you? They're going to go and check with you because they're like, what's going on with your car? I'm like, yeah, that's what I want to know. I'm like, I sold this car not too long ago. Why would you guys want to like...
Do you think that you'd... If everything pans out here, do you think you can drive your car home?
Oh, 100%.
Yeah, you think your car is operational?
At this moment, no, because what the hell? What happened?
You tell me. That's what I'm trying to figure out.
And I'm some Russian. I'm not lie to you. You can actually tell me that, oh, I'm not arresting for this. You can arrest me. You can go right ahead and arrest me for this. I have money to bail myself out.
Well, what do you mean arrest you for? What am I going to arrest you for?
To me.
All right, so you listen to me.
No, you listen to me.
No, that's not how it goes here.
No.
What am I going to arrest you
You
for?
want to press charges on me?
What am I going to arrest you for?
Go right ahead.
What am I going to arrest you
Listen
for?
to me.
What am I going to arrest you for?
Because like, oh, she's being a...
That's not an arrestable offense. What would I be arresting you for right now?
Because you're over here thinking that I'm talking back to you and you're over here like...
You can say whatever you want to me. You're not talking. No, now you're starting to get an attitude. All I did was ask you if you think that your car can drive right now.
It's not me telling you wrong. I promise you that. It's not me telling you wrong. Arrest me.
Well,
You really want?
we're not really there yet.
No, because you're like...
What do you mean? What do you mean?
No, because you're being...
I don't understand how you got
other people, there's been other people that have drugs.
I don't understand where you're getting this basis from, though. We came here because you crashed your car. Are you aware of that?
Am I aware of that? Yes, I am.
Okay.
Because I told him, I was like, I'm going to take you home. He's like, yeah, you're fine. You're fine.
Okay.
You know what?
No, stay in the car for me, okay? I don't want.
No, I don't think you guys arrest me. Why? Because I'm
Why
the
arrest
money
you?
for it.
I don't care about the money.
I'm a nurse. I'm a nurse. But you were.
Listen to me. Just calm down, take a breath. The fire department would like to talk to you.
You think I'm with the respect you? I'm a nurse.
Okay.
You think I'm with the
Do you have any
respect you?
complaints with the results of your
You
were sick? Are you waiting for anything?
let me tell you one thing.
It's more,
Let me tell you
it's
one
more
thing.
the passenger because he was like going in drugs or what's going on. What you talking about?
You know what? We're hanging around with the same people.
Reel me into your conversation. I don't think we're having the same conversation.
morning. Please be seated. Good morning, everyone. All right, we'll go ahead and go on the record. We had some brief discussion off the record regarding the schedule. And I believe the plan this morning, Ms. Thompson, is to begin with Mr. Safrick. And I see that he is on Zoom. Are you able to hear me this morning, sir?
I can, Your Honor, yes.
All right, and we can hear you loud and clear.
Perfect.
Ms. Thompson, was there anything we needed to address before beginning with the witness?
I don't believe so, Your Honor.
Okay, let's see if I can find my camera and I'll swear the witness in here. 1 second. Too many screens to keep track of here. All right, good morning. If you'd raise your hand, sir, I'll swear you in. Do you swear the testimony you're about to give will be true and correct?
I do.
Okay, whenever you're ready, Ms. Thompson.
Thank you, Your Honor. And Mr. Safrick, are you able to hear me okay?
Yes. Hold on 1 second. Let me just turn this up a little bit. Okay.
Good morning, Mr. Safrick. Can you please introduce yourself to the court?
Sure. My name is Mark Safrick. I am the president of Forensic Behavioral Services.
And what do you do for a living as the president of that company?
I conduct complex assessments of death investigations, death cases for interested parties to help them understand what happened, how those events within the case unfolded, and possibly sometimes why they occurred.
Are you familiar with the term equivocal death evaluation, Mr. Safrick?
Yes.
Can you tell?
Recording in progress.
Can you tell the court, Mr. Safrick, what an equivocal death evaluation is?
Sure. An equivocal death evaluation is an investigation where the manner of death, not necessarily the cause of death, but the manner of death is in dispute or in question, or where there are several possible scenarios that could explain the death.
And I want to get back to that concept with you, Mr. Safrick, but for starters, did you work in law enforcement prior to starting your company?
I did.
And can you tell us in general terms what your law enforcement career consisted of?
Sure. I started in 1977 in California with a local law enforcement city police agency. I started in patrol. I worked about 3.5 years in patrol, and then promoted into detectives, started in property crimes, and finished out my time there in violent crime investigation. Subsequent to that, I applied to the FBI. I got into the FBI in 1984. I served in various field offices. I served 23 years in the FBI, the last 12 plus years in the behavioral analysis unit.
In total, how long was your law enforcement career?
30 years.
And in total, how many of those years were with the FBI?
23.
And you mentioned that you worked with the behavioral analysis unit in the FBI. Can you tell me what you did in that unit?
Sure. So I worked there were 3 units. We had a child crimes unit, we had a threat assessment terrorism unit, and we had an adult crimes unit. So I was assigned to the adult crimes unit. I was responsible for, it's a relatively small unit. We had 8 criminal behavioral analysts. I was responsible for the 6 western states of the country for all cases that came in from law enforcement agencies from those locations. Most of the cases that I worked on were homicide cases, multicide, so serial murder, mass murder, spree murder, sexual homicide cases, and serial sexual assaults, all related to adults.
Did part of your work in that unit involve analyzing crime scenes?
Essentially, everything despite the services that we offered, everything within the unit requires a detailed analysis of the crime scene in whatever case it is and whatever we're being asked to provide to the requesting law enforcement agency. So it all comes down to conducting a detailed analysis of the scene, the antecedent behavior, the behavior during the scene, evaluating forensic evidence, physical evidence, and integrating all of that information together to understand the totality of the events that are occurring both in sequence and in time.
You told us earlier about this concept of equivocal death evaluations. Did you perform those evaluations while you were with the FBI?
I did.
And did you have experience at the FBI investigating cases where investigators initially believed the case was a homicide, but the case turned out to be something else?
Yes.
Have you published in the area of death investigations?
Yes, I've published, I have a book on spree murders for police investigations. I have numerous peer-reviewed international journal articles on various aspects of death analysis and investigation.
Have you trained law enforcement officers on the topic of death investigations?
Yes.
Can you tell us briefly about your experience training other officers on this subject?
So I regularly do presentations for law enforcement groups and other groups for forensic nurses, victim advocates. I've presented to judges, to prosecutors, to defense attorneys, homicide investigators, violent crime investigators around the U.S. and throughout the world. I would say, conservatively, I would say I've presented to over 20,000 law enforcement professionals.
Are you the member of any professional organizations?
Yes, there's a number of them that I have listed in my CV. American Academy of Forensic Sciences, the VDOC Society, it's a cold case society. Off the top of my head, I have them listed, I just don't recall them now.
In your consulting career since you left the FBI, what kinds of clients have you consulted for?
Well, since I left the FBI, most of the clients are, I would say, attorneys, civil attorneys. So the types of cases that I work on typically involve some type of violent crime. But I have done cases for prosecutors, for defense attorneys, and even for private parties. Sometimes family members will retain me to examine a case. And prosecutors, defense attorneys, and then in civil cases, both the plaintiff and the defense.
Do you have clients for whom you've consulted where the client ended up not using the opinions that you provided to them?
Yes, that occurred both in the FBI when we consulted with law enforcement agencies and also civilly. The cases that I've done in the nearly 18 years since I've been retired from the FBI, there will always be cases where the analysis doesn't line up with what the attorneys are looking for, and then they don't end up using me.
I want to come back to this topic of equivocal death evaluation and crime scene analysis. And for starters, Mr. Safrick, you are not a medical doctor, is that right?
That's correct.
In reaching your opinions about crime scene analysis and case investigation, do you rely on medical diagnoses that are reached by medical professionals in those cases?
I do.
And do you also rely on objective evidence that's gathered by law enforcement investigators and others related to a case?
Of course.
Mr. Safrick, are you here today to offer any opinions on whether any particular person related to the investigation into Ms. Mullis's death is telling the truth?
No.
Are you here today to offer any medical opinions?
No.
And the opinions that you're going to offer today, are those opinions that you hold to a reasonable degree of certainty?
They are.
You talked about this concept of equivocal death evaluation. How does an equivocal death evaluation differ from another type of homicide investigation?
So most of the cases that I've worked on, both in my FBI career and subsequently, typically involve a violent crime, oftentimes a homicide. So the advantage when you are working a case like that is that you know at the outset that the manner of death is homicide. So that's never in question. When you're working an equivocal death case, they actually are much more difficult to work because when you get the case, the manner of death is either in dispute or it's unknown. It could be undetermined, which is one of the five evaluations that you can have in the United States for manner of death. So the way that you approach an equivocal death is different than you would approach, say, a homicide case. Here, you have to look at all of the various attributes of the case in terms of what is consistent and what's inconsistent with a particular manner of death. Now, I would say that in most of the equivocal death cases that I have worked, when you look at the four manners of death, which would be natural, accident, suicide, and homicide, in most of the cases, you can eliminate usually one or two of the four. So you're usually left with two manners of death that you have to consider. So it's a more complex type of investigation because you have to consider various avenues of consistency and inconsistency with the forensic evidence, the physical evidence, and the behavioral actions that have occurred at the scene and how all of those translate both sequentially and in a time order or temporally.
Mr. Stafford, did you conduct an equivocal death evaluation into Ms. Mullis's death?
I did.
And did you review evidence related to the investigation into her death as part of your evaluation?
Absolutely.
Can you tell us in general terms what you reviewed?
So, what is important in literally any type of investigation is the initial police investigation. So that would be any investigation they did, any evidence that was collected, any testing of that evidence. In a death case, it would be the autopsy protocol, photographs and diagrams from the scene, any interviews of witnesses, the assessment of the scene itself. That is all the critical information. Typically, in those types of investigations, what occurs weeks or months later oftentimes isn't really relevant to what I'm doing because I'm doing a crime scene analysis. So it's everything that's attendant to the initial scene, which is typically frozen by police on their arrival.
And I do want to start talking, I want to start by asking you some questions about the scene that you just referenced. Based on your evaluation that you conducted in this case, did you develop opinions about the scene of Ms. Mullis's death?
Yes.
And are you aware that in this case, prosecutors argued to the jury that the scene of Ms. Mullis's death was staged?
Yes, I'm aware of that.
All right. So when we talk about the concept of the scene in the Mullis investigation, what do you understand to be the scene of where she was injured?
Well, okay, so I would say more broadly, the scene is literally the entire farm area of the Mullis farm. If we're referring just to the injury location, that would be the shed that stands between the house and the hog barns.
Is it your understanding in this case that Ms. Mullis died at the hospital?
Yes.
And why do you consider the scene to be the shed and the Mullis farm in this case?
Well, Okay, so I would say I would consider the Mullis farm, or at least certainly the area around the house and the shed and the workshop and the hog barns as the overall scene area, because there were witnesses and individuals in those locations. I would say that the shed is the location for Miss Mullis's passing, because there's physical evidence in the shed that suggests that the interviews that were conducted, the information derived from those interviews indicates that, and the police investigation and their theory is that her death took place in the shed.
In your training,
which I think is accurate.
And when you're talking,
her injury took place in the shed.
In your training and experience, what does it mean for a scene to be staged?
So staging a crime scene is an attempt by the offender of, say, the homicide, because that's typically where you see staged crime scenes, is in homicides. It's an attempt by the offender to misdirect the investigation. And the way that they misdirect the investigation is to introduce either spurious or fake evidence, remove evidence, or create contrived activities or behaviors that that actually didn't occur. And the idea is that the purpose is that they're trying to create a new scene that has a new motive, because that's what they want law enforcement investigators to look at and draw their own conclusion that this is what is actually occurring as opposed to what actually occurred. And so they stage the scene. The reason that staging is, and recognition of staging at a crime scene is important, because because strangers don't need to stage a crime scene. They don't have a relationship dynamic with either the victim or the scene or both. So when you see intentional staging, then it suggests that that the offender has some relationship with the victim or the scene or both of those.
So how is it that law enforcement evaluate whether or not a scene is staged?
Well, that's the point. So the offender, he manipulates the scene, either the forensic evidence or the behavioral evidence or the physical evidence. They manipulate the scene to change it so that when law enforcement comes and looks at the scene, that they're trying to overwhelm what law enforcement's logical conclusion about the scene would be, to make them think it's actually something different. So a new type of case that has a different motive. The problem is that when you are staging a crime scene, all of this activity then is happening after the crime. So it's not occurring in the right sequence or the right time order. And so you get inconsistent forensics, you get inconsistent injuries. You may have blood spatter in a location that doesn't fit the crime. So there are a lot of red flags that are evident in staged crime scenes.
Did you see evidence in this case that the scene of Ms. Mullis's injuries was staged in some way?
No.
And can you explain how you reached that determination?
Well, I would say first off, when you stage a crime scene, the point is that you need law enforcement investigators to come to the scene and look at it. You've changed the scene. You've changed the victim. You've changed evidence. You've created something that is supposed to look different. But you need investigators to see it, because you need for them to draw their own conclusions about the scene. Incorrect conclusions, but that's the whole point. So here you don't even have a scene, and that's the point. So there's no staging that's going on here, because investigators, they only come to the shed at a later time.
So why was there no scene in this case?
I'm sorry?
I said, why is it that there was no scene in this case, as you just mentioned?
Right. So there's no scene because, first of all, Amy Mullis is not deceased. And there's an attempt to render aid to her, both in the shed and then subsequently in the truck, and then subsequently at the roadside location where dispatch advises him to stop the truck and meet law enforcement. There's no scene. There's the victim is not there. Everything is, suggests that Mr. Mullis was attempting to render aid to his wife in getting her to the hospital. So there's no scene to analyze, not for staging anyway.
In your experience, is an aspect of scene staging sometimes that a person that is staging a scene will generate a situation where someone else will find the victim?
Yes, that's very common, and not even in staged scenes, but in other types of homicide cases where it's called, what we refer to it as third-party discovery. So what they don't want is to discover the victim, because then it creates a problem for them because they're not at an arm's length distance. So oftentimes they will have somebody else discover the victim. That could be a neighbor, it could be a coworker, it could be a friend. That puts them at arm's length from both the scene and the victim, and essentially allows them to try to create an alibi.
Well, here you're aware that it was not Mr. Mullis that found Miss Mullis. Is that right?
Yes, I'm aware of that.
And
yes.
in your evaluation of this case, did the circumstances of this case fit the third-party discovery dynamic that you just described?
I would say no for two reasons. One, in every third-party discovery, in any case I've ever worked, or any case that I'm aware of from my time in the FBI's behavioral unit, or in my 18 years subsequent to that, I have never seen a third-party discovery where a parent sends a child to make the discovery. It's typically an adult contacting another adult, not a family member, but, as I said, neighbor, friend, coworker, somebody that's disconnected personally, in a sense, from the victim. So that's not my experience to have sent. I've never seen you send a minor child to find, the parent. Secondly, it doesn't really work here because there's nobody here at the Mullis farm. This farm is isolated. It's out in the country. There are no houses around it. There were no other people. So it doesn't make any sense to send, if you're trying to do third-party discovery, it doesn't make any sense to send your minor child to make the discovery. For one, there's nobody else around, and two, the time frame is literally minutes. So we're not talking about hours or days. We're just talking minutes. So it wouldn't serve any purpose in terms of distancing yourself from the scene to send your minor child.
Did you see evidence in this case that Tristan Mullis was interviewed by authorities, soon after the events that brought Miss Mullis to the hospital?
Yes, he was interviewed within minutes after the event.
Did his availability for interviews influence your conclusion that there's not evidence of third-party staging here?
Yes, partially. It's one of the things that I would say is consistent with it. Because he's a minor, you have to have parental permission to interview a minor. And Todd gave permission immediately for Tristan to accompany law enforcement back to the house to show them and tell them what he saw, what he did, what he found. And so that's inconsistent, really, because if you're the offender, you don't want a third party to be making statements that might affect your credibility or whatever you've told law enforcement.
And did you see evidence in this case of Mr. Mullis interrupting or preventing law enforcement from interviewing Tristan without Mr. Mullis there?
Your Honor, I'm going to object to this line of question as improper expert opinion testimony because it's a comment on credibility, not only of Todd Mullis, but also of Tristan Mullis in this case. Credibility is a determination solely for the fact finder, and it is not subject to expert testimony under 570(2), 3, and 4, I believe.
Overruled.
I think I did not get an answer to that question, Your Honor. Is that correct?
I didn't hear an answer. You may.
No,
answer.
yeah, I didn't. Can you just repeat the question? I'm sorry.
I'll have to have the reporter read it back since there was an objection, so we'll give her a chance to do that.
Thank you.
And did you see evidence in this case of Mr. Mullis interrupting or preventing law enforcement from interviewing Tristan without Mr. Mullis there?
No, there were two instances where law enforcement asked Mr. Mullis if they could interview Tristan. One of them was immediately after, from the roadside location to accompany Tristan back to the house to explain the whole situation there. And then later on that day, they also asked him again, and he said, sure, go ahead.
Did that permission impact your conclusions here about the scene not being staged?
I think, as I said, I think it's one piece, right? Because clearly, if you don't know what someone's going to say, especially with a minor child, it would be very easy to say, I don't want you to talk to him, or I want him with me, for whatever reason. So I think it's a piece that, lends itself to suggest that he didn't care what Tristan told law enforcement, because it was going to be what Tristan's experience was that morning.
Did you see evidence in your equivocal death evaluation in this case that there was planning involved in some way in someone hypothetically causing Miss Mullis's death?
Right. So, I don't see any staging in this case. And, I don't see any planning. If the allegation is that it's staged, I think if it's planned, it would be very, very poorly planned for several reasons. One, the weapon is really a terrible weapon. Can it inflict fatal injuries? Yes. But is it a good weapon to use? No. If you're planning this, you don't want your children around. You don't want to be in a position where you literally would have to escape from your son to commit this. And also, you have two other minor children in the house, a 10-year-old and an 8-year-old. You have no control over them. You don't know where they're going to be, if they're going to come outside, if they're going to go to the shed. That they played in the shed. So it would be extremely risky. So to do that with your minor children would be, problematic. Farm accidents are very prevalent. So if you're going to plan this, if you've spent time to think about this, then there are lots of other ways that this could have occurred that didn't involve your minor children and didn't involve a very odd type of weapon like a corn rake. And it would have given you the privacy to interact with Amy at another location, somewhere off the farm property. But I just didn't see any evidence of planning, because I don't think there's no staging here. And if this is planned, it's extremely poorly planned.
Did the fact that Ms. Mullis passed away at the hospital in this case, is that a fact that you took into account in evaluating whether or not there was planning associated with her death?
Yes, because the idea in a staged crime scene, one, is that the victim is deceased, because you're going to be manipulating the scene, manipulating the victim. So the victim has to be deceased, because if they're not deceased, then there's a possibility they can move away, get help, render the aid to themselves. It becomes very problematic. So the fact that she's not deceased, again, in terms of planning, if this was the plan to kill her, then, that didn't succeed.
If Ms. Mullis was, if there was evidence in this case that Ms. Mullis was the person who suggested the family work in the barn the day of her injuries, would that contribute to your analysis of whether or not Ms. Mullis's death was planned in some way?
Yes, it affects it because because of her medical procedure, she had been unsteady, dizzy. She'd been resting at the house for several days. So it was, I believe, only on that morning when she informed Todd that she just couldn't sit in that house anymore and was going to come out and try to help in the barn. So again, how would you know this? You really wouldn't know it. So, it goes against planning. Additionally, in terms of the planning, if you're trying to stage this, so then you have to know where the corn rake is, right? You have to be able to tell police, yeah, I saw the corn rake there yesterday. I was in the shed yesterday. I saw the corn rake. It was right here. So because it has to be, the scenario would have to make sense, right? You're trying to make it make sense to the police. So yes, you're going to tell the investigators, yes, the corn rake was in the shed. I saw it in the shed. This is where I saw it, right? But that's not what you have here. Instead, when they asked Todd where the corn rake was, he's like, I don't know. I hadn't seen it for 2 weeks. Last time I saw it weeks ago, I'd set it against the wall, but I don't know where it was. So that doesn't make any sense if you're trying to stage a crime scene, right? You're trying to make law enforcement believe that this is, an accident, right? That's what you're trying. So you need to have the corn rake there, to confirm that for them, but it's not. And I don't think Todd knew until that morning that Amy was planning on coming out to the hog barns.
Is the topic of victimology relevant to equivocal death evaluations?
Yes, victimology is relevant to any type of crime analysis, because understanding the individual whose life is taken or who dies, is really important to understand their background, and what effect that has on risk level for them. So understanding that background, all aspects of that background, from their various types of histories, could be criminal or psychological or financial, their relationship dynamics with friends, coworkers, family members. All of that information is important to understand, who is Amy Mullis, and, what's that dynamic relationship between her, Todd, other people in her life.
Is that what that term victimology means, what you just described?
Yes, right. And it also, especially when you're talking about risk, you're trying to assess at what level of risk is she to become the victim of a violent crime. But on the flip side, you're also that also informs the level of risk that an offender is willing to take to commit the crime. So if you have a very low risk victim, which I would say Amy is, not only because of her lifestyle, but simply because she lives in a very isolated location that's difficult to really find and get access to her. But also, sorry, lost my train of thought. Also because, the risk would be very high for an offender to access her there. So risk is a balance between the victim and the willingness for the offender to take on, more risk. And the more risk an offender is willing to take, then the more important it is for them to, commit whatever act they're, preparing to commit.
Well, in considering victimology and in considering risk, in general, in conducting these type of equivocal death evaluations, do you consider the concept of infidelity in making that analysis?
Sure, if that exists, if it's relevant. So there are lots of different components to victimology, and their relationship dynamics in the relationship dynamics in her relationships would be important. So if it's uncovered that there's marital infidelity, certainly that would be important to understand.
Well, in conducting this equivocal death evaluation, did you consider the issue of infidelity in the Mullis marriage and reaching your conclusions?
Sure, absolutely.
And how did that fit into your analysis?
Well, so once I was aware of it, then I have to put it in context, right? So everything that's done in my type of analysis is always within context. It's always within the totality of the circumstances. It's never a single piece of evidence that, is pulled out and assigned a value. It only has meaning within the context of everything you're looking at. So when I became aware that she had this affair with Mr. Frazier, then I wanted to take that into consideration. What do I know about that? Who knows about that? Did Todd know about that? What's that dynamic? What is that dynamic like? So, of course, is a very important piece.
And did you draw any conclusions about how, if at all, infidelity would have played a role in the victimology in this case?
So one thing I really wanted to understand is, was Todd aware of it? Now, clearly, there had been a past infidelity that he was aware of. But in this current one, based on the emails and the texts between Amy, Jerry Frazier, Mr. Frazier's wife, several of her friends whom she confided this infidelity to, there's nothing that I was able to see that led me to believe that Todd was aware of the infidelity. I mean, Amy said he wasn't. Jerry said he wasn't. In fact, there was questioning by Todd in, I believe it was July of 2018, where he had seen a number of texts between Amy and Jerry, and asked Jerry about them. Or I think asked Jerry about them, and was given what appeared to be a reasonable explanation for it, and then spoke to Amy, and to the extent that I think he felt badly that he had thought there could be something going on, and actually apologized to Jerry and to Jerry's wife. And in texts between Jerry and Amy, they were very confident that Todd was not aware of the affair.
In considering the issue of victimology, in assessing risk factors as you've described, do you as an investigator think through the dynamic of someone reporting events differently to different people?
Sure, absolutely.
And did you consider that dynamic in this case?
Of course.
And what, if any, oh, go ahead. Go ahead, Mr. Safrick.
Well, so certainly, I mean, all of us have different relationship dynamics with people. We have our public lives, we have our private lives, and, you know, some people have a secret life. But it depends on the relationship dynamic with your friends. So some of your friends are more distant. They're almost more like acquaintances. And other friends are people you see all the time. And then other friends are like really close friends. That could be the same for coworkers. So when the stories and the conversations that you have with different people in your life basically reflect the level of comfort you have with them, what you will tell them. And so you see, I mean, when you look at the conversations that she has with several of her friends and with Jerry, you can see the difference in the conversations, and that I think would be expected.
Is it?
Do you need power? Yeah. There's a power strip right in front if you can reach.
Yeah, and I had them check it.
I did get an answer to the last question, right? I don't need it read back. I just want to make sure. Okay, thank you. Did you see evidence in your evaluation, Mr. Safrick, that there were communications between Ms. Mullis and Jerry Frazier where Ms. Mullis was critical of Todd Mullis?
Yes.
And what, if any, conclusions did you draw from those communications in terms of Ms. Mullis's victimology?
I didn't think that there was anything wrong with those. You know, she has this secret affair going on with Mr. Frazier. I mean, she's violating her marital vows. She's, you know, there's probably some level of fantasy, you know, that's going on here. So I think based on the conversation she was having with Jerry, at some point, you know, she feels badly and she's looking for someone to sort of buoy her up, right? Support her, almost, I don't want to say like a victim mentality, but certainly, you know, that kind of, you know, where it's, you know, she's looking for sympathy. She's looking for someone to, you know, provide support for her, right? To make her feel good. I think those kinds of texts with Jerry, you know, if you're commenting on your relationship with Todd, I think it, you know, makes sense, you know, when you're talking to somebody who's, you know, your secret lover. I didn't see anything that, you know, that caused me any kind of, you know, concern.
Did you see any differences in the communication between information that Ms. Mullis was conveying to Mr. Frazier and information that she was conveying to Todd?
Sure. I mean, I think, she's married to Todd. She has children with Todd, right? They have a business together. So some of the texts that she's sending Todd are very playful, loving, discussing things that I think any normal couple would be discussing, things happening on the farm, breakfast, just sort of innocuous kinds of conversations. She did say that she loved him, but of course she's got this secret side of her. So obviously she's not going to tell Todd about that, but it doesn't mean that she doesn't care about Todd. And I mean, that's the sense I got in reading a number of messages. And you can't just read one. You have to put them in context. You have to read a lot of those, and a lot of those messages to her friends, and evaluate, what is that relationship? What is she comfortable telling these different people?
And Your Honor, again, I'm going to object on well beyond the scope of expert testimony. We're just commenting on text messages and things that are well within common sense and reason. And that is not subject as a reliable expert opinion under 5702 and 03, and therefore should be excluded under even 403B.
I mean, I do think we're getting pretty far afield here, Ms. Thompson. If you want to try to tie this back in, that's okay, but I'm not sure what your next question is.
I mean, I'm moving forward, Your Honor. I would just say that there was some testimony from Mr. Firehelm that he personally, in his analysis of the case, believed that there were, and I don't remember his exact words from yesterday, but that basically his own evaluation of the marriage was different than what Mr. Safrick's describing. And one of the ineffective assistance of counsel claims that Mr. Mullis has is that his counsel didn't consult with someone who could have provided context. So this is relevant to Mr. Mullis's ineffective assistance of counsel claim. I agree that, and it's not this witness's intention or our intention to argue that this witness can provide, veracity about these issues, but more context for counsel to have evaluated the issues here and how to present them for Mr. Mullis.
Your Honor, if I may be heard.
You may.
Well, that's certainly not what he authored the report for, to comment on Mr. Firehelm's testimony. He makes direct credibility determinations, and he coins it under a term victimology. There's at least 2 cases which have excluded his analysis specifically on this point and reversed for new trials as it being inadmissible in the first place and therefore unreliable. I'm happy to provide those citations now. They're from the Illinois Supreme Court, where they find the entirety of this testimony and line of questioning to be inadmissible, as did the New Jersey court that they relied on too, because it's the equivalent of testimony from a 13th juror to parrot in a theory of a case. That is improper testimony, and we would vehemently object under the expert testimony provisions in 403.
Yeah. And certainly little different to have the testimony of trial counsel's analysis of the case and attempting to get the testimony in this way through an expert. So again, if you can have him explain how he's qualified as an expert to talk to me about this specific type of testimony in a way that isn't vouching or credibility, which is my domain, I guess we can try to go there. But the way this direction is, or the way this testimony is going, seems to be down that path at the moment. So let's maybe redirect and get back into something that I think is his domain with these investigations, or the way in which he handles them, please.
Understood, Your Honor. And we can take up the issue of that case law because we disagree with what it says, but I understand the court's ruling, and I'll move on to a different topic.
Thank you.
Mr. Safrick, are you familiar with the concept of confirmation bias?
Yes.
And can you tell us in brief terms what that is?
Well, I would say in reference to like a criminal case, the investigators are more likely to search for and recognize what confirms their bias or their theory and ignore or not consider evidence to the contrary.
Did you see evidence of confirmation bias in the investigation into Ms. Mullis's death?
And I'm going to object again, Your Honor. This is psychological evidence, and it's been kept out before because they do not have, he has no experience as a psychologist. He has no medical experience as a psychiatrist. What is the point of this testimony? Again, under our reading of the case law, courts have kept out the very same thing and found it to be improper, and we would object on those grounds as before. It's the same grounds as before.
Did you wish to respond to this, Ms. Thompson?
Well, the case law that the primary case in Illinois in which a court determined Mr. Safrick's opinions were not relevant actually dealt with his assessment of a crime scene. If the state is referencing People versus King, we can talk about that case. This is not testimony that's offered to provide, the purpose of this testimony is to talk about what this investigation was and why it is that both Mr. Mullis's own attorneys and investigators focused on incorrect information. And that is it within Mr. Safrick's province as a experienced FBI investigator, as an experienced law enforcement officer who evaluates these cases. It's to understand why both Mr. Mullis's own attorneys and the authorities would have focused on particular issues without looking at others. And that's relevant to understanding why it is that Mr. Mullis didn't receive effective assistance of counsel, and why it is that this investigation got off track, which again is one of the claims that Mr. Mullis raises in his petition.
And again, Your Honor, if I may, Mr. Safrick's report doesn't speak to that. The ultimate conclusion as set out on page 56 and 57 is meant for him to speak to whether or not this was an accident or a homicide. Specifically, if we look to his conclusion, he said, quote, "I was asked to review this case to determine if a manner of death other than homicide would provide the most logical explanation for Amy's death," close quote. I believe that's at page 57, Your Honor, possibly 58. And so Mr. Safrick's conclusions certainly aren't being relevant to an ineffective assistance of counsel claim. And again, improper testimony invades on the fact finder's function here.
Ms. Thompson, any further response?
Mr. Safrick has not offered an opinion about the cause of death here, although he certainly has one, as the state alluded to. There's nothing about, and his report does discuss the topic of confirmation bias and how that is relevant here. These opinions are just as relevant for what counsel would have taken into account in choosing whether or not to investigate, choosing whether or not to make certain arguments on Mr. Mullis's behalf. That is exactly the purpose of his report. It's information that counsel could have taken into account. That's exactly what we offered it for in our petition, that counsel failed to get this kind of expert opinion, which would have aided in counsel's analysis. There is nothing about Mr. Safrick's report that is inconsistent with presenting it in that way. We have not presented Mr. Safrick's ultimate opinion in this case. That is the province of the court. But these are all the factors that he could have explained to counsel, which would have helped counsel understand what evidence would have been relevant to arguing this case to the jury in Mr. Mullis's case. And I'd say that there's a number of other cases where Mr. Safrick's analysis and opinions have been accepted by courts, and we have a number of those cases we can cite to the court. So the state has pulled out, a couple where courts went the other way, but that's not Mr. Safrick has testified all over the country, and his opinions have been accepted by courts in numerous states.
To the extent that the court understands Mr. Safrick to be offering an opinion as to the investigation that was conducted into this matter, and not an opinion or as an expert on confirmation bias specifically, the court will allow the testimony and give it whatever weight it's ultimately due. So the objection's overruled. You may proceed, Ms. Thompson.
I'm sorry, what was my last question? And I apologize because I don't recall. I believe the last question may have been.
Do you see evidence of confirmation bias in the investigation against Mullis?
Did you hear that question, Mr. Safrick?
Oh, I didn't. No, I did not.
Let me repeat it. Did you, Mr. Safrick, see evidence of confirmation bias in the Mullis investigation?
Yes.
And can you explain what evidence you saw of that?
Well, I think the first really important piece here relates to the interviews that were done of Tristan and Todd. It's important to understand that the first 3 interviews of Todd, well, 2 of them occurred, the first 3 occurred on the day, on the 10th. The first 3 interviews of Tristan, or first 2 interviews of Tristan also occurred on the 10th. At no time were those interviews conducted with Todd and Tristan together. They were all conducted independently. In fact, all of the interviews that were conducted, including the ones on the 16th, were conducted independently. So normally in law enforcement, when you have 2 suspects and that are, suspected in a crime and law enforcement arrests them, the first thing that law enforcement does is separate them. Why? Because they don't want them talking and getting their story together. I mean, this is an investigation 101. And that's exactly what happened here. We have these literally 7 interviews of a 13-year-old boy and Todd explaining to law enforcement on the day. So this isn't occurring weeks later or months later or years later. This is happening contemporaneous with the crime. And what we know from investigations is that the best information from a witness is that contemporaneous information to the event. So the closer to the event, the better, because you don't want that information contaminated. You don't want that person talking to other people
Objection,
or other
vouching, improper testimony. Again, what he's saying is, if I understand it, and certainly the court can make the determination, is that they were telling the truth because their stories were closer in time to the events in question. How is that not a credibility determination, saying they were telling the truth then, but were not later on?
Well, and I think the answer is turning into a narrative. Let's just have a new question, please, Ms. Thompson.
I'll ask another question, Your Honor. Did you see evidence of confirmation bias in the way that authorities relied on the text messages and the messages between witnesses in this case?
Yes, in certain circumstances I did.
And can you explain what evidence of confirmation bias you saw in that respect?
Well, there was a couple of texts that Amy had related to a confrontation that she'd had with her mother-in-law, Peggy Munson. And those texts, if you take the text out of context, it appears that Amy is talking about Todd, that she's going to, if this ever happens again, I'm going to leave, take the kids. And then, so it sounds very damaging by itself, but if you take it within the context of all of the other texts, you realize that she's not talking about Todd. She's talking about her relationship with her mother-in-law and the problems that she had there. And that goes on for a couple of days. And she even has that discussion with Todd. So I think it's really important that you take all of these conversations in context and look at what's going on before and after the conversations.
Just one moment, Your Honor. The text messages that you were just referencing, Mr. Safrick, do you understand that that Miss Mullis's mother-in-law in this case was Elaine Mullis? Do you recall? Go ahead, Mr. Safrick.
Sorry?
Do you recall, as you sit here today, the name of Mr. Mullis's mother or Miss Mullis's mother-in-law?
Yeah, sorry, I misspoke. Right.
In general, the testimony that you've provided today, if Mr. Mullis's counsel had consulted with you before Mr. Mullis's trial, is this information that you could have provided to Mr. Mullis's attorney?
Yes.
I don't have any other questions, Your Honor.
Cross-examination.
Yes, Your Honor. Good morning, Mr. Safrick.
Good morning, Counselor.
How long have you had what was your experience length in law enforcement specifically?
In law enforcement?
Yes.
Well, I started in 1977 as a police officer working in patrol. As I said, I promoted into detective, started in property crimes, went to violent crimes. And then in 1983, I applied to the FBI. I got in, and my first office was working in Indian Reservation in Wyoming. I worked there for 3.5 years, working all the violent crimes on the reservation. I went and then was transferred to the New York City office. Is this what you're looking for?
Mostly, I was just trying to check. I believe it's 30 years or so that you had in law enforcement, right?
Oh, yes, yes.
So is the bulk of your experience testifying in court is actually from an agent perspective, correct? Or an officer perspective too?
Well, I was a supervisory special agent in the behavioral analysis unit.
Right, but in court cases specifically, is the bulk of your testimonial experience when you've taken the stand has been as an officer or an agent, right?
Yes.
And your background is in law enforcement specifically, fair?
That's very broad. I don't know what you mean by law enforcement.
You have no expertise or specialization in psychology, fair? You're not a psychologist?
Correct.
Not a psychiatrist?
Correct.
As you confirmed on direct examination, you're not a doctor, right?
That's right.
So you're in the fields of psychology, such as social psychology, you aren't able to speak to the dynamics between people, fair?
No, I wouldn't say that's true.
Well, you are not a social psychologist who has been certified to testify on that matter specifically, the social psychology of interfamilial relationships, right?
No, I testify about relationship dynamics all the time as an expert witness.
Correct, but your primary expertise, in fact, for the bulk of it, your expertise in the field of crime scene analysis or law enforcement investigation, right?
Well, I would say that crime scene analysis is the baseline for all of the type of analysis that I do, yes.
And in your report, you detail it as crime scene analysis as being your primary expertise as well, fair?
I don't know that I detail it in my report that way. As I said, crime scene analysis is sort of the bedrock of all of the type of analysis that I do in complex death assessment cases, whether they're homicides or serial murders or equivocal deaths. I have extensive training in that area.
Correct, but on page 3 of your report specifically, you say, quote, 2 published appellate opinions allow my expert testimony in crime scene analysis, right?
Right, I have lots of opinions. I have lots of appellate courts that have upheld my testimony many times. I only put those in there because they were published opinions.
Well, the Illinois Supreme Court also issued a published opinion in People v. King. Are you aware of that case?
I am, yes.
And they found, in that case, would you agree that the appellate court or the Supreme Court of the state of Illinois found your testimony inadmissible in its entirety, correct?
Yes.
And it relied on a similar case by the New Jersey appellate court as well, finding similar testimony on profiling, for instance, or what your testimony was being offered in that case went beyond the bounds of your expertise, correct?
I've never testified about profiling. Profiling is not allowed in the court. Profiling is essentially linking the defendant to the behaviors at the crime scene that would interfere with the purview of the jury and the court and the judge. I've never testified about criminal profiling. And
Not even
are
in
you
the
speaking
case
about,
of,
are you speaking about the Fortin case?
well, on the matter
You're
of,
talking about the New Jersey. Are you talking about New Jersey? Is that the Fortin case?
I believe it's State v. Lennon, if that sounds correct.
Yeah, that's the Fortin case, yes.
And similarly, you were found or profiled as an ex-FBI profiler in the case of, I believe, Raymond Lee Jennings, correct? Are you familiar with that case?
Objection.
Yes.
It just, the question, I think, was you were found or profiled as an expert. I just didn't understand the term that the counsel was using there, Your Honor.
Did you wish to clarify, counsel? I mean, I guess I heard the witness answer, so apparently the witness wasn't confused.
I mean, I can clarify, Your Honor, but the witness already answered the question.
I guess, Ms. Thompson, if you just want to come back on redirect, you can clarify.
Understood, Your Honor.
Well, you mentioned that you've never done profiling before, and you would agree that it would be inadmissible testimony to do a profile, correct?
Yes.
But similar matters, or I guess your testimony in People v. King at the appellate level labeled your testimony profiling of characteristics consistent with crimes. Would you agree with that?
I don't know how they characterize it, but I've never testified about profiling.
So today you're not providing a profile, for instance, of who would have committed this crime, right?
No.
But you are profiling the victim in what you've coined as victimology, right?
Right. You have to understand the history of the victim is when you're looking at a death scene case.
You comment on her behaviors as being manipulative or otherwise, right?
Objection, Your Honor. That was not his testimony today.
Overruled. The witness can answer if he's able.
So part of so you're taking things out of context here. I said that when you look at Amy's conversations with various people, she presents a different side of herself to whomever she's talking to. That is a relatively normal thing most people do, depending on the relationship that a person has with the person they're talking to.
But you would agree. Thank you, Mr. Stafford. But my question really was, you refer to her at times as being described as manipulative or otherwise. Fair? In your report?
Yes, I did.
So those findings comment on her characteristics as a victim, right?
Well, I've characterized a lot of things about her.
Right, her personal traits, fair?
Right, and this was also referred to by other witnesses who described her the same way.
So I guess, Mr. Stafford, you're just going, is it fair to say that you drew all of your inferences from the existing record evidence established or collected by law enforcement on this side of things, or presented at trial? Is that about right?
Well, I didn't do any independent investigation. I didn't, go to the scene and conduct an investigation. So as I always do, I have to rely on the reports and the investigation conducted by law enforcement and others associated with the case, like the medical examiners and toxicologists and such.
But on direct examination, you testified that there was no scene in this case. Is that right?
There was no staged scene.
Well, you would agree that Amy Mullis was found on her hands and knees on your review, right?
She was found with her hands tucked under her, yes, lying on the floor in the shed.
And she was found impaled by a corn rake.
Yes.
And you would agree that based on the evidence you reviewed, at least, Mr. Mullis sent his son to find the pet carrier check on it, right?
Correct.
And ultimately sent him in to find his mother. True?
I don't think he sent him to find her. He sent him to get the pet carrier.
And in doing so, find his mother, right? Or found his mother.
He did.
And then Mr. Mullis grabbed the corn rake and pulled it out of Miss Mullis's back, right?
Yes.
And in doing so, touched the weapon, in this case, or what would be called a poor weapon, I believe, as you characterized it, right?
Yes.
And so there wouldn't be any DNA evidence specifically that you'd be able to pull from the handle of the rake, right?
Why wouldn't you be able to pull DNA evidence?
Well, let's say fingerprints. Mr. Mullis's fingerprints would be on the rake then, right?
They could be.
So in your experience of 30 years in law enforcement, you would agree pulling latent prints might be difficult, right?
Pulling a latent prints depends on the surface you're pulling them from. So if you have an old, worn, dirty corn rake handle made out of wood, probably be difficult to pull latent prints.
And so when Mr. Mullis pulled the corn rake out of Amy Mullis's back, he discarded it next to her at some point, right?
Yeah.
And you would agree that based on the record evidence, Mr. Mullis admitted to putting the rake in that shed, correct?
Well, yes, his recollection was that, 2 weeks prior, he set it against, but he hadn't seen it since. Set it against the wall, but hadn't seen it since.
But he was the last person, based upon your review of the records, who knew or saw that corn rake with any certainty, right?
Yes.
And it was Mr. Mullis who sent Amy Mullis to get that pet carrier, correct?
Yes.
So he sent her to a specific location, right?
Yes.
For a specific purpose, right?
Correct.
Where nobody else would be, true?
Well, he didn't know that his other children wouldn't be out there.
Well, you're speculating on that front, fair? You don't know one way or the other. You have never interviewed those kids, and you have no testimonial statements one way or the other as to whether he thought they'd be in there, right?
Objection, Your Honor.
No, but look, I'm looking
sorry,
at
Mr.
this.
Saffrick, there was an objection.
Oh, I'm sorry.
I'll withdraw the objection, Your Honor.
Oh, now the objection's withdrawn. You may continue your answer.
So I'm looking at all of this is what is reasonable, what is likely by reasonable inference. So the information is that Todd and Tristan were in the hog barn with Amy for an hour maybe. So there's no way he would actually know where his other two children were.
Well, he left them inside the house, right?
Yeah, but they're 8 and 10, they're kids. So
well, in the middle of
you'd have to be certain
but
they weren't going to be outside.
But you can't be certain that he didn't know they were going to remain inside, right? Because you don't have any independent information and you have conducted no investigation yourself, right?
Correct.
You speak at length about the manners of death to be investigated, right? The 5 different manners of death that are recognized, true?
Well, just in terms of an equivocal death evaluation, yes.
But ultimately, you agree that in your conclusions, you were asked to provide an opinion on whether the manner of death in this case was homicide or that there was a more logical explanation for Amy's death, right?
Right. When I got the case, I didn't know anything about the case in terms of, I knew how she died, but what the manner of death was, I didn't know. That was my point. It was to conduct an equivocal death evaluation that basically determined that it was either going to be that the 2 most consistent manners would either be homicide or accident.
So your conclusion was the 2 most consistent manners of death, in your opinion, would be homicide or accident.
Right, because there was nothing there that indicated this was a natural death, and there was nothing, in my experience, in terms of having seen well over 4,000 homicide cases and death cases, that this was a suicide. So, by reasonable inference, you're left with either accident or homicide.
You would agree that Google searches in the history as introduced at trial, though, about, quote, what happens to cheaters in history, and, quote, killing unfaithful women would point to potential motive or any purpose, right? Based on your understanding of planning.
Well, see, counselor, I think you're taking that out of context. That's not very good of you to do that. It's completely out of context. Those searches appeared to be related to schoolwork.
Your testimony today is that, quote, killing unfaithful women was a school assignment?
You're taking it out of context. I think that's my opinion. There is information that suggests that these were searches done by the kids.
And I might have missed it in your report. Did you at any point reference those Google searches?
No, I did not.
So nothing that would have potentially cut against the point. You only found one factor that weighed in favor of finding it was a homicide, right?
Objection, Your Honor.
Yes, I did.
The basis of your objection, Ms. Thompson.
That's a compound question, Your Honor, but the witness has answered, so I'll withdraw the objection.
The objection's overruled. The answer will remain in the record.
And that was that most women are murdered by people they know. That's right?
Yes.
But you didn't weigh any other motive evidence, did you?
Counselor, I reviewed all this information in detail. I was open to the possibility that this was a homicide and that the counsel that contacted me was, incorrect. And that was my job, to figure out what, based on the information and my review of all the information, what was the most likely and consistent manner of death. That was my job. And I considered it a homicide as well.
Well, correct me if I'm wrong, but in your report, you don't mention Tristan Mullis's trial testimony, do you?
I don't know. I listed everything that I used, that I received and reviewed. I have to say that I wrote this report in the end of 2022, beginning of 2023. So it is several years old for me at this point. But I have listed everything that I reviewed.
Well, I'll ask you this question. Do you recall anywhere in your report that you testified to your conclusions at length on direct examination, for instance? That report, do you mention Tristan Mullis's testimony that Todd Mullis's father was out of his sight for an indeterminate amount of time?
If you can reference to me, I believe you're referencing an interview with Tristan that occurred well over a year after the incident.
I'm not, Mr. Safrick. Did you review the trial transcripts in this case?
If I have them listed, I did.
But you don't make reference or note them in your report, do you?
Well, I listed in my report what I reviewed.
So I guess I'll phrase it in the hypothetical then, Mr. Safrick. In your opinion, if Tristan Mullis under oath swore that his father left the hog barn and left his site for an indeterminate amount of time at trial, would that change your testimony?
No.
Why?
Because, as I said before, the initial interviews are, in my experience, the most accurate, and when they're contemporaneous with the event. They were unfiltered, unbiased, unimpeded, there was nobody to influence him. By the time trial has come around, what he heard and who has talked to him and who has influenced him, I don't know. But those kinds of, that kind of testimony is problematic for me. I relied on the contemporaneous interviews done by law enforcement on that day, multiple interviews with both Tristan and Todd, independent, where their stories were exactly the same.
Well, Mr. Safrick, I'm going to ask a follow-up question on this one. Does it change the fact that at each time Tristan Mullis took an oath to tell the truth and testify in a deposition or a court proceeding like you did today, does that weigh in favor of finding that to be a potential protective factor that maybe this was a homicide?
Again, I reviewed in my complete review that everything suggests that this was not a staged case and that this was not a homicide.
Correct. But my question was, does Tristan Mullis's sworn testimony that Todd Mullis left his site change the fact that those are his under oath statements, and the statements you reference were not under oath?
Objection.
I
Your Honor.
understand.
Objection, Your Honor. That misstates the testimony and the facts in this case.
Overruled, the witness can answer.
Yes, so I understand what you're asking. I understand that those statements were under oath, but I would consider them. But I would say that in the context of everything that I reviewed, the contemporaneous statements made by a 13-year-old boy were accurate, and he repeated those statements. And not only that it's consistent. His statements and Todd's statements are consistent with what would be expected if you found your wife, unresponsive in a shed. Those activities of lifting her head and wiping her face, all of those things are consistent with somebody rendering aid, yelling at your son to get the truck. Those are all consistent, and those statements were consistent. So I would value those statements in the context of everything that I reviewed more than I would the statements under oath.
So his sworn testimony is less than the unsworn statements, yes? Did I just understand that correctly? I'm only confirming as a yes or no.
Sure. Yes. Yes. That's how I would view that. Yes.
Do you have your report in front of you, Mr. Safrick?
I do.
Can I refer you to page 6 if possible?
Certainly.
Let me know when you're there, please.
I will. Okay.
In the first paragraph at the top of page 6, in the last sentence, I believe, I'll read aloud and let me know if I read it correctly. Quote, "In this case, I yielded the attempt to reconstruct an exact sequence of events. Such an attempt is impractical due to the innumerable possible interactions between Amy, the environment, and others." Did I read that correctly?
Yes.
In your opinion, then, an accident reconstruction wasn't feasible here. Is that fair to say?
No, that what I'm saying is that oftentimes when I'm questioned at trial, counsel will ask me, isn't it possible that this could have occurred? And generally what I would say is that when you're dealing with what's possible, literally thousands of things are possible. It's impossible to know the exact sequence to the second of what is actually occurring. So rather than dealing with possibilities, which is nearly impossible, my job is to look at what is likely by reasonable inference from the evidence, the physical evidence, behavioral evidence, forensic evidence. I can't deal with what's possible. The possibilities are endless.
Well, I appreciate that,
Mr.
Mr.
What
Safrick.
I'm saying there.
I appreciate that, Mr. Safrick, but on
Sure.
page 6, you are speaking about reconstructing the exact sequence of events, correct?
Right.
And so you said such an attempt to, quote, reconstruct an exact sequence of events, I believe those are your words, is impractical, right?
Correct.
So in your opinion, it would be impractical to be able to speak to any certainty about the exact sequence of events, right?
Yes, you can't speak to certainty about the exact sequence, and I can't know the exact sequence of literally any crime that I have looked at, but I can draw reasonable inferences based on the evidence.
So just to clarify, I guess, as we work towards the end here,
Sure.
we can agree that Todd Mullis asked Amy Mullis to go get the pet carrier, right?
Yes.
So he sent her to a location, right?
He did.
And we can agree that at least Tristan Mullis's sworn testimony was that his father left his site for an immeasurable amount of time or an unknown amount of time, right?
Objection, Your Honor. That misstates the testimony.
Well,
I don't know what the sworn testimony was.
the answer will remain in the record.
But you reference and cite in your report, which you have in front of you right now, Mr. Safrick, that you reviewed the trial transcripts, right?
Like, I don't know. I have multiple pages of things I reviewed. I don't recall if I did, or if it's listed here, I did. I just, I just have multiple pages, and it's a couple years ago I wrote this, so.
And in this period of time, you have never once evaluated reports or information provided by a Valentina Nye, for instance, right?
I'm sorry, by who?
That, I think, answers my question. You haven't referred to reports or reviewed reports from one Valentina Nye, right?
No, I have not. Dr. Nye? No.
Correct. Dr. Nye would be a way to
No.
refer to her.
That's correct. I have not reviewed any reports of hers.
And your conclusions around the scene and the distances between buildings aren't based on your research or your findings specifically, right?
Right, I relied on other experts who conducted those measurements.
And would you agree that there is a difference or a distinction between one being dead or deceased and one being pronounced dead?
I'm not clear on your question.
Sure.
Someone's dead or they're pronounced dead?
So Amy Mullis was pronounced dead at the hospital, correct?
She was.
But she was found unresponsive in the shed on your review, correct?
Yes.
And there were not signs of life accordingly at that point in time. Is that a fair description of the evidence or the record?
Objection, Your Honor. This is calling for a medical opinion from this witness, which he stated he's not providing.
Well, the witness can certainly, I guess, testify as to his understanding based on his review of the records. I won't interpret his testimony as providing any medical opinion. With that understanding, Mr. Safrick, you may answer the question if you remember it at this point.
I do. Thank you, Your Honor. Yes, I don't believe there was there's anything that indicated that she was dead in the shed. She was transported. They were doing CPR on her at the roadside. And I believe, my recollection serves me correctly, that the doctors in the hospital worked on her for over an hour. So at some point she was pronounced deceased, but there's no evidence that she was deceased when Todd found her in the shed.
Did you find any?
She was unresponsive, but no indication she had already passed.
Did she ever come to or become responsive again based upon your review of the evidence?
Counselor, that would be a question for the emergency room doctors who worked on her. I don't know.
Although you just testified to what they found or how long they worked on them, right?
I believe that my recollection is they worked on her for about an hour before they pronounced her.
But you can
So
come to
my sense is that they believed that she was alive. I mean, I have a lot of experience with individuals who are either declared deceased at the scene because it's apparently obvious they're deceased, or as soon as they get to the hospital, they're declared deceased. That's not what occurred here. So
she wasn't declared deceased at the hospital?
Not immediately. I've had, hundreds and hundreds of cases where offenders or where victims are declared deceased as soon as they arrive at the emergency room. But that was not the case here. So I don't know. There's nothing that says that she was deceased, and people believed because they were working on her that she was still alive.
Sure. Mr. Safrick, we were provided a list of your prior testimony in the last 4 years. I believe that lists, is it 2 trials that you've testified in? Or one
I
trial?
don't have that list in front of me, but whatever, it should be accurate, yes.
How many trials do you believe you've testified in the last 4 years or so?
Trials, probably those two.
And
If there's two on there.
you also list depositions, I believe, for a grand total of 4 items or 5 items or so. Does that sound about right?
Yes. If I provided that, that's accurate, yes.
And it isn't in criminal cases specifically, right?
Well, they're civil cases, but they're all related to criminal, typically homicides. So I have to evaluate all of those homicide scenes.
Sure. And how much were you paid for this case?
Well, not enough, but I did a lot of the work pro bono after I got paid initially, but I've done a lot of work pro bono, and I've not, just because, they don't really have the money, and I think it's worthwhile to provide my insight in this case.
Thank you, but that didn't actually answer my question. How much were you paid on this case?
I think 10,000.
Okay. And how much pro bono work have you done?
I do a lot of pro bono work for various organizations. All my work for the VDOC Society is pro bono. I do other cases pro bono. So.
Right, but I am asking specifically about this case, Mr. Stafford.
This case. Right. A lot of my time, probably, 25 to 30 hours has been pro bono.
Is your hourly rate $500 an hour for a 4-hour minimum?
That's my testimony for depositions, but my hourly rate is $400 for analysis and casework.
And how many hours have you done of work on this case?
I don't know offhand.
Could you ballpark it like you did for the 25 to 30 hours of pro bono work?
60 to 70 hours of work. It's been I was retained in July of 2022. So it's been, 3 plus 3 years.
So 60 to 70 hours of work total or inclusive of your quote unquote pro bono hours?
That's probably total.
I don't have anything further. Thank you.
Any redirect?
A few questions, Your Honor. Mr. Stafford, I'm going to show you what's been marked as Exhibit 281. While this is being pulled up, this is a multi-page document, and I'm going to have my colleague scroll through Exhibit 281, and I'm going to ask you if this looks like a true and accurate copy of your CV and your report in this case.
I'll object, Your Honor. This isn't in evidence, and certainly it includes hearsay statements and testimony, and we would, have that evidentiary fight later on, but we've been having it for quite some time, so as the court knows, we would reiterate our same objections here. Also, this report's unsigned out of compliance with the rules of civil procedure and therefore not properly affied to. But we would raise our standard objection. Thank you.
All right, thank you. I guess, counsel, were there additional arguments that you wish to address at a later time with regard to this exhibit, or?
I'm just showing him a CV, Your Honor. That was my intention right now.
Okay. Well, go ahead with that for now.
Yes, this is my CV. When I update my CV, I change the date at the bottom of the pages, so it shows January of 2025. I think I had an article published, and so I updated the CV, but that's accurate.
All right, and Exhibit 281 is a true and accurate copy of your CV and your report in this case?
Well, all I can see is the CV at the moment. But yeah, that's my CV, yes.
let me know when you've had a chance to determine whether this is a true and accurate copy of your report.
Okay. Yes. I was looking for the date on it. Appears
right.
to be yes.
Your Honor, we can,
It's 57 pages. If it's 57 pages, then yes.
all right, and Your Honor, we can take up any other issues with this document at a later time.
All right, we'll do that.
You can take the document down. You were asked some questions about medical issues in this case. Did you review reports from a forensic pathologist and a biomechanical engineer related to the Mullis case, Mr. Safrick?
I did.
And do you defer to the expert opinions of those experts in their respective fields?
I do.
And do you, when you indicate that you are not able to determine sort of when you are not able to determine exactly how events might have transpired here, do you intend to offer an opinion about whether a biomechanical engineer could offer opinions about that topic?
No, I don't.
I mean, are you disputing any of the opinions of pathology and biomechanical experts in this case?
No, I'm not.
You were asked some questions about the rake and some of the things that occurred after Ms. Mullis was found in this case. Was Mr. Mullis removing the rake from Ms. Mullis, was that an attempt, is that behavior that's consistent with staging a scene?
No.
Why not?
Again, the purpose of staging is to create a scene that law enforcement can attend. The investigators can attend and then see the scene and make their assessments on the adulterated, changed scene. Because again, you're trying to create a new motive for the crime, and then that's what you want. That's what you want law enforcement to see. So you don't create it and then destroy it. And everything that I saw is consistent with him rendering aid. It's consistent in their statements as well, with him rendering aid.
If there is testimony in this case that Mr. Mullis's daughter, who was a minor, saw the corn rake in the shed near the time that Ms. Mullis suffered her injuries, would that change your opinion that Todd Mullis was the only person to reference seeing the rake in that area?
Objection leading.
Overruled.
Yes, I knew that the kids played in the shed, and Tristan suggested at one point that maybe they had moved the rake. But I don't think anybody knew where the rake was. It was never identified in a particular location, except I think Todd said a couple weeks prior, he put it against the shed door.
And are Todd's statements about where he left the rake, are those consistent with someone staging the scene as you've testified about?
Objection, vouching and improper testimony for through prejudice.
Sustained.
I didn't ask you your opinion about how you would evaluate the cause of Ms. Mullis's death, but the state did. So I'll ask you, did you reach a conclusion about what the likely cause of Ms. Mullis's death was?
Objection, improper opinion testimony. He can't come to a pathological diagnosis, Your Honor.
They opened the door to this, Your Honor.
Did you want to respond to that, Mr.
Sure.
Rudin?
We didn't have a report. We didn't ask for his report to provide us an ultimate testimonial determination. Ultimately, the question was, isn't the basis of your report in the ultimate conclusion for you to decide whether or not this was a homicide or an accident? That's what's cited at 56 and 57. When he was coming to a determination, he said he couldn't speak to a manner of death specifically because he's not to undermine the pathological opinions or the medical opinions here. Simply put, that's the basis of that testimony, was to object on the basis of that he is not an expert who can provide that and render an opinion.
Yeah, I guess, Ms. Thompson, that's how I understood the witness's answer as well. If you understood understood or believe something differently, you may respond, but otherwise the objection sustained.
Well, this, just to make clear my point, Your Honor, I mean, the state asked him a number of questions about why he did not determine this was a homicide. We don't intend to offer him as a medical expert. He's not a medical expert. But given that they inquired about those conclusions, it's our position we should be able to inquire about his conclusions as well. But I understand the court's ruling, and I'll abide by it.
Thank you.
One moment, Your Honor. Two more questions, Your Honor. One is, Mr. Safrick, you were asked some questions about whether you're testifying as a profiler in this case. Are any of your opinions in Mr. Mullis's case based on your experience in profiling possible criminal defendants? Your Honor, I don't know if the witness was able to hear me. It might have been because my mic was off. I apologize. Let me just read. Mr. Safrick, I assume you could not hear my question. I apologize. I think my mic was off. So let me restate.
No, I didn't hear it. I didn't hear anything.
Apologies. Let me restate that question. You were asked some questions on cross about whether the opinions you were providing in this case were based on your experience as a profiler. And my question for you is, are any of the opinions that you're offering about the Mullis investigation opinions you're offering in the context of being able to profile potential criminal defendants?
No.
I don't have any other questions, Your Honor.
Any recross?
None needed, Your Honor.
All right, thank you, Mr. Safrick. It appears that your testimony is complete. I'll go ahead and end the Zoom at this time.
Thank you, Your Honor.
For those of us here in the courtroom, this is probably a good point to take our morning recess. Let's break for about 15 minutes and plan on picking up at 11:20. Court is in recess until then. Please be seated. Ms. Nichols-Cook, additional evidence?
Yes, Your Honor. The applicant would call Lynn White.
All right. Ms. White? Take your time, please. You can come forward and have a seat in the chair to my left.
There's no chair.
Yep, go ahead. Oh,
There's no chair.
our chair disappeared. Well, that's interesting. We can grab one from over here. Thank you. Thank you. All right. If you'd raise your right hand. Do you swear the testimony you're about to give will be true and correct?
Yes.
Okay. You can turn that microphone on in front of you there. There's a button in the bottom center. And then feel free to adjust the chair and the microphone so that you can sit comfortably.
There you go.
Yep. Okay.
What was the second part of that? I'm sorry.
Oh, feel free to adjust the chair and the microphone so that you can sit comfortably.
All right.
Okay. Ms. Nichols-Cook, whenever you're ready.
Thank you, Your Honor. Good morning, Ms. White. How are you?
Good morning. Very well, thank you.
Can you state your name for the record and spell your name for the court reporter?
Lynn White, W-H-I-T-E.
And Ms. White, how do you know Todd Mullis?
I am his older sister,
And where do you currently live?
Dubuque County.
Did you grow up here in Delaware County?
Yes, I did.
And what do you do for work?
Currently, I am a office manager for a construction company,
How long have you been there?
14 years.
Prior to that, what did you do?
I was a city clerk treasurer for a small town in Dubuque County for 10 years, a neighboring county for 5 years as a deputy clerk, and I also worked in the banking industry for 5 years.
Do you have other siblings in addition to Todd?
Yes.
Who are they?
I have an older sister, Lori, an older sister, Mike, and the two younger boys, Pat and Todd.
And Mike's your brother.
Correct.
We've heard some references in other testimony about Lynn and Mike. Would that be you and your brother, Mike, that people are talking about as far as helping with things around the family farms?
Yes.
And then is Leroy Mullis your dad?
Yes.
Do your parents and your brothers all live close to where Todd and Amy Mullis were living in 2018?
Yes, all within about 5 miles.
And does your family, including your parents and your brothers, do they currently farm?
Yes.
Have they always farmed?
Yes.
Is it crops or livestock?
Both.
Both. In the spring of 2018, do you know who was planting crops?
Todd planted the corn and Mike planted the beans.
And in 2018, do you know who would harvest crops?
In 2018, it was Todd that ran the combine along with Mike.
Can you tell us about your relationship with Todd's wife, Amy?
I was in their wedding. I am the godmother of their daughter. At holidays, we would play cards together, do the dishes together, throw darts in the yard. I would stop on occasion to the farm and just visit.
I want to talk now specifically about the summer and the fall of 2018, okay?
Okay.
Do you remember learning that Amy's grandmother was ill and eventually passed away?
Yes.
Did you learn about any other family issues that Amy had going on that were
I-
affecting Todd and the kids?
I believe that her uncle was also in the hospital. He had some sort of brain bleed, and she was assisting her mom in taking care of her uncle.
Do you know if that required Amy to be gone from Delaware County at times?
Yes.
Did you have interactions with Todd and the kids and Amy during the summer and the fall of 2018?
Yeah, I would see them on occasion, yes.
Did you have any concerns about Todd and Amy's relationship?
None.
I want to talk now specifically about November 10th, 2018. Do you remember what you were doing that day?
I was babysitting my 2 grandsons.
Did you get a call that day about Amy?
Yes.
Can you tell us what you did after you got that call?
After I got the call, I assigned the babysitting duties to my husband, and I jumped in the car and I went to the hospital.
What did you see when you got to the hospital?
At the hospital, we went into the family room, and there was some friends that were in the family room along with Todd sitting in a chair. His eyes were red. I could tell he had been probably crying or was upset. And there was, I believe, I'm not exact, but I think that, there was other people in the room, but I don't know who they were.
Okay, no, that's okay. And if I ever ask a question that you're not sure about, please ask me to ask it again.
Okay.
While you were in the waiting room, did you learn that Amy passed away?
They had come and asked Todd to go back to the emergency room where she was at, and when he came back, they said she had passed away.
At this point in time, what was your understanding of what had happened to Amy?
There was a farm accident at the farm, something with the red shed.
Did you help Todd with the logistics and the arrangements for Amy after that point?
Yes.
Did you help him make the funeral arrangements?
Yes, I went along with her mom and stepdad, and Taylor, I believe, also went along to help, and we made the funeral arrangements in Manchester.
After the funeral arrangements had been made, did you learn that there were concerns that Amy's death was not an accident?
When I was going up to the farm, on, I believe it was the 16th, I had called Todd that I was on the way, and he said that he had gotten a call from Sheriff LeClaire that he wanted him to stop in at the office, and they were going to get the file basically kind of wrapped up, closed up, and so we could move on. So,
and I don't want you to, I want to make sure I keep asking. So on November 16th, is that when you became aware that there were concerns about Amy's death not being an accident?
yes.
Okay. And so at that point, you learned that the sheriff wanted to see Todd. What did you do?
I picked him up and I drove him to the sheriff's office for this interview to get it wrapped up. I waited in the waiting room.
Do you know how long you were in the waiting room while Todd was with the sheriff?
It was approximately 2 to 3 hours at least.
What happened when you and Todd left the sheriff's office that day?
They had told me they issued us, what do they call them, subpoena, and that they wanted to get Amy's phone from the farm. And so we basically drove back to the farm then with just in the car with the subpoena or in our hand, was reading it, I guess.
Could it also have been like a search warrant?
Oh, yes, that's what it was. Sorry.
Okay. At that time, did you learn what investigators thought had happened to Amy?
I'm going to check. This is calling for based upon hearsay.
Well,
overruled. The witness can testify as to her understanding.
When I went into the interview room, Agent Turbot had said that we know Todd did this.
So at that point, in your mind, what are you doing? Like, what are your next steps?
I guess I was in shock, number one. Next step, I thought, where are you coming up with this? Because it was a farm accident. And I was trying to think, who do I call? So.
Did you contact
my
an
mind
attorney
was.
between the sheriff's office and the farm?
Say that again.
Did you contact an attorney between leaving the sheriff's office and arriving at the farm?
Yes.
Were you at Todd and Amy's then when the search warrant was executed on the 16th?
Yes.
How would you characterize your interactions with law enforcement during that process?
After we had given them the phone, they wanted to see the buildings. And when we were walking to the building, Travis Hemesath turned around and said, you need to tell your brother.
Sustained.
If you can characterize it without repeating what someone said to you, as far as was it hostile or angry? Was there a lot of back and forth? What do you recall observing and being a part of?
Can you re-ask that again? Sorry.
Yeah. When the search warrant is being executed on the 16th, can you describe for us what was happening? Were officers also talking with you and Todd?
I'm going to object, Your Honor, on hearsay and backdoor hearsay, even if we're cabining it where it's not saying specifically what they said, it's based upon those statements and observations of those statements.
Yeah, I mean, I think that question is probably inviting hearsay, Ms. Nichols-Cook. I'm not sure if maybe you can rephrase.
Let me try, Your Honor. Thank you. Would you characterize the interactions that you had with investigators as being aggressive towards you?
Same objection, Your Honor.
Overruled.
You can answer.
Yes.
After the search warrant was executed, did you help Todd make any adjustments to the funeral arrangements for Amy?
Yes. We spoke with Bob Sabers, and we just plain asked him, do we want to wait on getting the cremation process delayed if there's going to be issues?
I'd like to show the witness exhibit 310, just the first page. Let me know if it pops up on your screen.
It's not popping up for some reason. Just a second here, counsel.
Your Honor, maybe approach the witness and show her one of our screens.
You certainly can. It's not acting like it's connected at all, so I'm not sure what the issue is.
Ms. White, do you recognize that document?
Yes.
Can you tell us what it is?
It was the letter that was drafted to by Leonard Funeral Home in order to have them delay the cremation.
I object on hearsay on this letter. The letter is not in evidence, and it's signed by Mr. Mullis, so it's hearsay.
Okay. The objection's overruled. The answer will remain in the record. And you had not offered it yet, correct, Ms. Nichols-Cook? All right.
Ms. White, did you help Todd write this letter?
We talked to the funeral home, and the funeral home director is the one that wrote it.
And did you?
I was
type
on the
it up
phone
and
call.
prepare it?
I was on the phone call with the funeral director at the time, yes.
Did you type up this letter?
I don't remember.
Have you seen this letter before today?
Yes,
And is what you've seen today a true and accurate representation of the letter that you helped Todd prepare for the funeral home?
yes.
At this point, we would move page 1 of 310 into evidence.
Mr. Bakke?
With the caveat, we're just talking about page 1. I have no objection on foundation, but I would object on the same hearsay grounds that it's signed by Mr. Mullis.
.310, page 1 is admitted. The objection's overruled.
Thank you, Your Honor. Ms. White, I want to move on a little bit and talk about, you mentioned Bob Sabers earlier. Is he an attorney?
Yes,
Were you involved in hiring counsel or representation for your brother Todd?
I assisted, yes.
Is Mr. Sabers one of those attorneys that you met with and hired?
Yes.
Do you recall when you first hired Mr. Sabers?
After talking to the lawyer on the way back to the farm, we also asked him, it was not the type of law that he had or practiced. So he suggested some names. We're like, who do we talk to? So he suggested some names and we called Bob. Actually, I called Bob, but
Thank you. Do you recall the date that Todd was arrested for Amy's murder?
February of 2019.
And at that time, did you let Mr. Sabers know about the arrest?
Yes. I was at work and I got a phone call from my brother Mike. And so then I proceeded to call Bob and find out what was going on.
And so at some point, did another attorney become involved in representing Todd on these charges?
Yes.
Do you remember his name?
Jake Firehelm.
And while these attorneys were representing your brother, was Todd in the county jail?
Yes.
And at times, was he also moved to the Buchanan County Jail?
Yes.
What was your role with the attorneys while they were representing Todd?
I was kind of the middleman as far as communications. I was the gopher to find information to get to them.
Were you in communication with Todd while he was in the county jail?
Yes, he would call.
How often would he call you?
Probably at every 2 or 3 days, every day. It just depended on the week.
When you said you were the middleman or the person, does that mean you were asking the attorneys questions?
Yes.
And were you also then providing them information or answers to their questions?
Yes, correct.
Was Todd asking you questions?
Yes.
Were you able to give Todd any answers?
None other than they're working on things, because I didn't want to get into details over the phone.
Why was that?
The phone calls are recorded.
Do you recall Todd writing notes and letters to the attorneys while he was in jail?
Yes.
Would you also then get copies of those from the attorneys?
I would get the originals from the attorney.
I want to show the witness a prior exhibit 233.
Oh, and it came up. It popped up now.
Thank you. Ms. White, this exhibit has several pages, but looking at the first page, do you recognize it?
Yes, it's one of Todd's letters.
And we can scroll slowly for you. Does this appear to be a continuation of Todd's writing?
Yes.
Okay. What about this page?
Yes.
And the next one?
Yes.
And the next one?
Yes.
And on this one, do you see a date at the top?
Yes. August 29th, 2019.
Based on your recollection, is this before the criminal trial?
Yes, that was in September.
Next page. Is this also Todd's writing and continuation of the prior letter?
Yes.
And same question here.
Yes, continuation.
And we've covered all the pages in that exhibit. So can you tell us a little bit about what types of questions and information Todd was looking for while he was in jail?
Well, he kept asking if we were going to have the scene recreated, if we could possibly get experts on what they were looking for.
I'm going to object on hearsay grounds. Party opponent to himself.
Overruled. You may continue with your answer.
Can you repeat the question, please?
Yeah, I'll ask you another question. Did Todd and you have conversations before he went to jail about, what would happen if he was arrested?
Yes.
And did you get kind of chosen to help, be a voice for him?
Yes.
And so when Todd would communicate with you, either via letter or phone calls, would you take concerns that he had to the attorneys?
Objection leading.
Overruled.
Yes. I would call them and just call them like every day. What's going on? What are we doing?
And did you also send them emails?
Yes.
At any point, did they start sending you updates about the case and what was happening?
They would send phrases along saying we're working on things and just tell me they were working on things. I mean,
what was your understanding of what that meant? We're working on things.
Objection. It's based on hearsay and vague.
Sustained.
What did you think was happening at that time?
Objection calls for speculation.
Asking for her own understanding and to explain the actions that she takes next. It's not asking her to repeat any out-of-court statement for the truth of the matter. It's what she thought was happening.
If you can clarify as to the time period, the witness may answer.
Ms. White, during the time after Todd's arrest, before his trial, when you would have conversations with the attorneys and they told you they were working on things, what did you think was happening?
I'm going to object again on hearsay and speculation.
Overruled.
Well, they shared things with me, and in sharing things with me, I would ask them what's being done about materials they had shared with me. If they were working on things, we kept telling them too, it's an accident. What are you finding out? Are you going to recreate this? What are you doing?
Okay. And you said they were sharing things with you. What types of things were you getting?
I got just about everything. Medical examiner reports, her medical records. I got police reports. I got the Celebrate information. That's what I can recall right now.
And I know earlier I briefly asked about your work history, but to clarify, that didn't include any investigative training or experience?
No,
Any cell phone, Celebrate
no.
type of experience? Do you remember talking with anyone else besides the attorneys directly during this process, during this time period of leading up to trial that worked with the attorneys?
Yes.
Who
I
would that
talked
be?
to the secretary for Jake Firehelm, and the two of us collaborated on a lot of the issues that we had in front of us. I would do things on the Celebrate. I would work up reports and figure out how to get everything in line, and then I would call Christy and ask her if she saw the same thing, and told her basically, she's like, how did you get that? So then I went through the steps on pulling up the Celebrate information and told her how to basically connect everything together. And then she would let me know that she was going to show this to the attorney, Jake, and share it with Bob.
Did you ask her if they had an expert to review the
I
digital?
told her, I asked her, I said, we need somebody to look at all this. We need a computer guy to do this. But when she asked, well, how did you get that report? I would explain to her and tell her in detail how I come up with the report I had.
I'm sorry, I didn't hear your objection.
Hearsay. Thank you.
Overruled. The answer will remain in the record.
To your knowledge, as you know, the person who was representing your family with these attorneys, did either attorney ever consult or hire an expert to review the evidence that you were getting copies of?
We asked several times, but I was not informed anybody was hired, and I kept inquiring, who do we have?
In the weeks leading up to the trial, did the attorneys ask you or the family for any information or assistance?
Yes, we provided them with drone footage of the farm a few days before the trial. We provided them with pictures of the barns, the area where Todd was working at. We provided, actually, Bob had emailed me asking me if I would draft some questions about.
Objection. Hearsay.
Sustained.
It's okay. So was this the first time they'd asked you to do things to help with their
Not the
representation?
first time. I offered, what can we do? How can we help? What do we need to do to help in the accident, to get information out to show.
And then did you write questions for witnesses
Yes,
and provide those to the attorneys?
yes, since the attorneys didn't have a background on some of the people on the deposition list, they just said, can you give us a little background on these people and maybe draft some questions as to what to ask them in the deposition?
Had you ever hired and worked with attorneys before?
Hired, I've got a tax attorney. Other than that, through my work at the city, we had a city attorney. At my job now, we have attorneys there. I mean, I don't hire them, but I
For a
work with them.
personal matter, for a family matter like this?
Not for a family matter like this, no.
Did you have concerns that you brought up to the attorneys before trial?
I kept asking them, are you going to talk to Todd about what's going on? Are you in communications with him? Does he have everything he needs as far as what's going to be presented? Several times we talked.
What was your impression after phone calls with Todd about whether he had information about what the attorneys were doing?
I'm going to object that this is based on hearsay or backdoor hearsay.
Sustained.
I need just a moment, Your Honor.
Sure.
Would Todd communicate frustration to you?
Yes.
Same objection.
I'm not asking for a statement. It can't be hearsay if it's not a statement. So I would,
Overruled. The
Thank
answer will
you.
remain in the record.
were you able to discern why Todd was frustrated?
Yes, he would state that the attorneys would, sorry,
Objection hearsay.
I didn't hear that, sorry.
Without telling me what Todd would say, could you discern, what it is you needed to do next?
Objection, this is backdoor hearsay.
I'm asking for her actions, what she did next. So it's not truth of what Todd said, it's the effect it had on her and what she did.
Objections overruled. Ms. White, just be careful to talk about what your actions were and not what statements were made too, okay?
Okay.
All right, you may proceed.
The actions that were taken was to get a hold of the attorneys and see what was going on.
So you were asking more questions.
Yes,
And would you also send them emails?
yes,
Did they ever ask you to review pleadings before they filed them?
yes, they would send me drafts and I would help them with some grammar and punctuation, that type thing, yes.
Prior to trial, did you ever learn that the attorneys were not going to pursue an accident theory?
No,
Did you attend the criminal trial?
yes, every day.
Were you present in the courtroom during the defense opening statement?
Objection relevance.
Overruled.
You can answer.
That's all. Yes, I was.
What was your reaction to the opening statement?
Objection relevance.
Overruled.
Shock and dismay, wondering where it came from.
During the trial, did you attempt to speak with the attorneys?
Yes,
Did you ask them questions?
yes,
Did that include wanting to know what the plan was for the trial?
yes,
If you had been informed before the beginning of the trial that counsel was going to concede Amy's death was a homicide, would you have done anything?
I'm going to object as calls for speculation and relevance as to her thoughts of what the trial strategy was.
Sustained.
Ms. White, if you had been informed or made aware about counsel's opening statement, would you have taken any action?
yes.
What would you have done?
Objection, this is relevance into what her actions or statements or conduct would have been in response to trial counsel's trial strategy is not relevant.
Right. Sustained.
If you had known, would you have gotten new counsel for your brother?
Same objection.
Sustained.
Were you ever consulted about conceding homicide?
Same objection.
Overruled.
No,
To your knowledge, was Todd ever consulted?
Objection. There's no foundation that she was aware of every conversation between trial counsel and relevance, even if there was.
Overruled.
I was not aware of any communications on that, no.
Do you recall talking with Todd after he testified at his trial?
Yes, he called us on the way home, I believe.
Was he upset?
Yes,
Were you upset?
correct.
At that time, in 2019, did you think Amy's death was an accident?
Say that one more time.
At the time of the trial in 2019, did you think Amy's death was an accident?
Yes,
Have you learned anything that's ever changed
no,
your mind? Did you meet with the attorneys after the trial?
yes. We met with Jake. Bob, we didn't meet with him, I don't believe.
Did you ever learn that Todd now thought Amy's death was a homicide?
Objection based on hearsay or backdoor hearsay. It's whether it's if she learned that information, it's based on statements that were made to her. So even if it's cabined in such a way that it's not reflecting the statement, it is based upon the information that was learned that is hearsay.
Sustained.
Miss White, has your brother always maintained his innocence to you?
Yes,
And then I think I just have maybe one thing I forgot to ask you in the beginning. Do you recognize this glass fixture that I'm holding up?
yes.
Can you tell me what it is?
It's a light cover that they use in the hog buildings to go over the light bulbs.
Did you provide this to the attorneys for
Yes,
the current attorneys for Mr. Mullis?
yes, I did.
And did it come from the hog barn at the Mullis farm?
Correct.
Your Honor, at this point, we would move to move Exhibit 275 in.
Any objection?
Not on foundation, just on relevance.
275 is admitted.
And Your Honor, I know it's noon, and I need to queue up perhaps my last exhibit. If the court could give me a minute, or if the court wants us to come back after lunch, I'm fine either way.
We can keep going, I think, if it makes sense to finish up your direct.
Ms. White, do you remember, we were talking earlier about talking with Todd after he testified at his trial, if that would have been September 22nd, 2019?
Yes.
And I know you mentioned earlier that the calls, when Todd would call you from the jail, they would be recorded. So do you remember him expressing frustration about the questions he was asked on cross-examination?
I'm going to object on hearsay.
So far, as long as you're not responding to specific statements that were made, the objection will be overruled. You can answer.
Was he expressing frustration?
Yes.
And Your Honor, I would like to play this call that we're talking about. I believe it's a prior consistent statement of Mr. Mullis, and so it would satisfy an exception to any hearsay objection to aid Ms. White in her testimony.
And I anticipate I know which jail call this is, Your Honor, and I would object that this is not a prior consistent statement that was made under oath at a prior court proceeding. This is simply a jail call between Mr. Mullis and his family member. It falls directly within hearsay. Mr. Mullis, of course, could have testified about his own recollections, but he can't testify through another witness.
Which exhibit is this?
It's in the jail calls, I think 375, and there's 686 jail calls in there by my count. So.
Ms. Nichols-Cook, I guess, as far as the issue of it being an exception or not, any further record you wish to make on that?
Yes, Your Honor, I think that there was a lot of cross questions about Todd's testimony at trial and whether he conceded it was a homicide in his testimony. And this phone call comes directly after that, in which Mr. Mullis explains that he still thinks it's an accident, but he didn't know how else to answer that question on cross-examination. And it is consistent with all of his prior statements to law enforcement that her death or her injuries were the result of an accident. And that is what he continued to tell his family and his attorneys throughout the process.
Okay, again, though, if this is Mr. Mullis's statement that you're using, correct, not this witness's?
Yes.
All right. So we'd still have a hearsay problem then, it sounds like.
I do think it could also fall under the residual hearsay exception.
And just for purposes of the record, there has been no notice of residual hearsay exception being intended to be used at this trial.
So at this point, I'm not thinking that this would be admissible.
Okay, I can move on, Your Honor, and
All right.
ask a final question. Ms. White, have you continued to support your brother throughout his legal proceedings?
Yes.
No further questions.
Okay, Ms. White, you may step down for now.
Your Honor, I think I can keep this very brief if that's acceptable.
Absolutely, certainly. You may go ahead with your cross.
Thank you, Your Honor. And I guess good afternoon now, Ms. White.
Good afternoon.
It's just so we're all clear, you are Todd's sister, right?
Yes.
And it's fair to say you love your brother.
Yes.
You care very deeply about him,
Yes.
and that you did everything you could in your power to assist him with his defense.
To keep communications between him and the lawyers and just to keep the ball rolling. Yes.
And you still believe in his innocence and want to see him be successful in this action. Is that fair?
He is innocent.
You were asked a couple questions about helping review pleadings. Do you remember that?
Yes.
Would an example of that be, so there was a bond issue, I believe. Were you asked to review specifics about how much land Todd owned, for example?
I had to give background on that, yes.
So that would be an example of specifics you were providing to the attorneys to put into the pleadings.
Just a small portion.
You are also aware, or are you aware generally, that if an attorney talks to you, if you're not the client, that it would waive attorney-client privilege?
I was not aware of that.
Are you aware of it now, generally?
I did not know that, no. I believe Todd had permission with the attorneys or told the attorneys that they should be talking to me as well so that I could be his middleman on the outside, I guess you'd say, to help with communications and make sure that the process was functioning and moving along.
Thank you. I have no further questions. Thank you.
Any redirect?
One question, Your Honor. Ms. White, did the attorneys ever give you any information about what their strategy was going to be to pass on to the family or to Mr. Mullis?
Never.
No further questions.
Any recross?
No, Your Honor, and just for the record, we would release Ms. White from our subpoena as well. And thank you.
Okay, thank you.
Okay, thank you. Now you may step down, Ms. White.
Okay, thank you.
All right, let's go ahead and take our lunch break at this time. I think, council, based on our earlier discussion this morning, Ms. White may be our last in-person witness. Is that correct? At least from the applicant's side?
Yes, Your Honor, that's my understanding.
Okay. I know that we have several witnesses that will be presented through their deposition testimony or by stipulation or other agreement. And the state may need an opportunity to confer before there's any final plan as far as presentation of in-person testimony. I don't know, counsel, were you in a position to commit to that at this time?
Yes, Your Honor, I can commit. As the court and both parties know, we have been attempting to ask our questions during cross-examinations to streamline matters, so we will have no additional witnesses to call at this time, just the depositions and the evidence that has been presented.
Okay. So I guess more for the benefit of those who are here observing, there would not be any additional in-person testimony. The remaining matters that need to be addressed between the parties and the court would consist of arguments regarding some remaining evidentiary issues, and then I guess discussions and clarifications regarding the agreements regarding the remaining witnesses that we have to talk about. I know that council is continuing to work on some agreements as far as how that testimony would come in specifically for the court's consideration. So we'll certainly pick up with that after lunch. And then once we've concluded that, I'll provide both parties with an opportunity for some limited oral closing argument. And both parties will then also have an opportunity to submit brief written legal briefs to the court to identify any legal authority that they believe would be particularly helpful. So we'll discuss deadlines for that as well when we come back this afternoon. I anticipate that our arguments and our discussion regarding the evidentiary issues will take some time. I would propose that both parties have up to 15 minutes for any oral closing argument that they wish this afternoon. I'll also provide the applicant an additional 5 minutes for a rebuttal closing, since it is the applicant's burden. So we'll plan on concluding with that at the very end of everything else that we need to do this afternoon. Anything of a housekeeping nature that we should address then before we break for lunch on behalf of the applicant?
Nothing, Your Honor.
Anything on behalf of the state?
No, Your Honor.
Okay, let's plan on picking back up then at 1:30. All right, I'll see you back here then. Thank you.
Please be seated.
Okay, we'll go back on the record. Just before lunch, both parties, well, I guess both parties rested in terms of calling live witnesses. However, I think at least the applicant has additional witnesses to identify by deposition. Is that correct, counsel?
Yes, Your Honor, I believe they're on the exhibit list, and the court would like, we can go through them.
Yes, let's do that, please.
Exhibit 204, Turbot 2019 deposition.
Okay.
And I believe that both of these have already been submitted.
Yeah, we did some of them maybe at the beginning.
Yes.
Yeah. There's 258, Hemisath 2019 deposition.
All right, and you show both 204 and 258 as having been previously admitted.
Okay. And then, Your Honor, 301 is TRM video deposition in 2019.
And that was previously admitted.
Okay. And then 316, 2024 deposition of Peggy Munson.
Was previously admitted.
317, deposition of Jonathan Turbot, 2023.
317 was previously admitted.
Your Honor, is it okay if I just read a few of the next numbers to verify?
Certainly.
318 through 326 should all be depositions taken in 2023 of witnesses. I think the 323 would be one the state would want to talk about.
Yes, I agree with that, Your Honor.
That we want to talk about it?
Yeah, that we would want to talk about 323.
Yes. And I do not show 325 as being admitted.
And that would be the additional one that the parties have agreed upon.
All right, thank you.
And then, Your Honor, just to verify, 327 through 337 are also depositions. And I don't believe earlier we admitted 337, as that was Mr. Thomas.
I'm sorry, counsel, can you tell me those numbers one more time?
327 through 337.
My notes show that it was admitted, but either way, we have no objection to that.
Okay, and that's what my notes show as well, that those would have been part of a stipulated group from Tuesday of last week, so.
And then the last of the depositions should be 338 through 344, and I believe we've already all agreed and admitted those.
Yes, I show that those have all been admitted.
346, some, and 352 got left off that page.
I show both 346 and 352 as admitted.
And then 355,
355 is admitted.
so the only one we would be asking to admit that the state's objecting to it this time is the deposition of Jake Firehelm from 2023, marked as 323. Applicant recognizes Mr. Firehelm did testify, but his deposition had to be utilized multiple times during his testimony to refresh him or to correct his testimony. And we think it's appropriate at this time to ask the court to admit it for the proper weight of what it was used for.
Counsel?
And the state would object to the admission of the deposition. And I would just note for clarity of the record that this was a discovery deposition. I believe it was taken before the state even had the benefit of receiving discovery. Not that there was any problem with that, given the timing of when it occurred, that was to be expected. However, given the timing, the fact that it was a discovery deposition, it, in the state's opinion, does not make sense to admit it. And as Mr. Firehelm testified in his testimony here on Friday, confirmed that he did not have his own file when he had that deposition. I believe the parties were able to adequately impeach or refresh his recollection based on his deposition, so his testimony should remain as what he gave in court.
Any further argument in support of your request to admit 323, Ms. Nichols-Cook?
Your Honor, I think our goal here is a complete record for the court to have, and it is additional sworn testimony that Mr. Firehelm gave in addition to the affidavit that he signed and was shown. And I believe the deposition will assist the court in evaluating his credibility and his testimony this week.
323 will be admitted.
Thank you, Your Honor. Your Honor, I believe the parties have an agreement as to Exhibit 371. This is a DCI Google search comparison chart created by Roman Gamble, and we would seek to admit it.
I show 371 as having been previously admitted.
I believe it was referred to during Sheriff Hemeseth's testimony. However, in any event, we have no objection to it. I believe he laid sufficient foundation for that.
Okay, if it wasn't previously admitted, it will be at this point.
And Your Honor, I know in our last witness, we talked about 375, the jail call records. We would still move to admit for the court's consideration just the September 22nd, 2019 phone call recording that is within that exhibit. It might be more as an offer of proof because of the objections that were made to its admission, and ask that it be admitted as an offer of proof.
$375 was
Yes.
the number. Okay.
There's many phone call recordings within that electronic exhibit, and we're just specifically asking for the September 22nd, 2019 call. I apologize, I don't have a better way of identifying it for you.
Okay. I guess to the extent it's being, or the court's being asked to consider it as an offer of proof, any additional record you wish to make on that point, Mr. Bakke?
Yes, Your Honor. The state objects to the admission of the jail call for the reasons already stated and addressed in the record, hearsay among others. I guess I'm confused. what the purpose of admitting it for an offer of proof would be at this point when no additional witness testimony is expected. So we would object to its admission.
Well, the court will consider it as an offer of proof, just so that it is part of the record for purposes of any further proceedings in this matter.
Thank you, Your Honor.
Or even refile that.
Just that once.
All right. And I know we have some other exhibits to talk about. Ms. Nichols-Cook, does that address all of the additional witness testimony that was coming in on behalf of the applicant through deposition?
Yes, Your Honor, there's one topic regarding Mr. Saber's deposition. The exhibits used in that deposition are separate exhibits on this court's trial exhibit list. And I know the state had some objections to some of those. And I don't know if the court would like me to identify which ones I believe are referenced in Saber's deposition for the record, or what's the best way to do that?
That's probably the best way to do it if they're not all contained within the same exhibit. So Mr. Saber's deposition is which number?
320, what? 323? 325.
Okay. And then the exhibits that go with Mr. Saber's deposition.
That would start at 219, Your Honor.
Okay.
220. 223. Yes, 223, I'm sorry. 234. 235. 236. 237. 238. 239. 240. And actually through 246. And then 247. Through 252. And 278. I believe those are all the ones referenced in that deposition.
Okay. So some of these are on my list of previously referenced exhibits that were problematic. I don't know if those are the ones that you're referring to, or if it is some of the newly identified exhibits that are troublesome, I guess. Mr. Bakke or Mr. Duden, Did one of the two of you wish to identify which exhibits are objected to, or do you need a minute to confer?
Your Honor, our objection is only to what we had previously expressed during our pretrial motions as well. That we would ask that those exhibits and depositions be considered for their weight because they do contain hearsay, rather than more so for the truth of the matter asserted. But we would also note that 252 has been previously admitted as a part of 233. I believe it's the later pages of 233 are in the middle section. Either way, for clarity of the record, we don't have an issue because it's cumulative and the court's already admitted it. And subject to the state's objection on the use of hearsay testimony in those exhibits, we don't have any objection to those being included here.
All right, so 325, the deposition of Bob Savers was previously admitted. And then as I understand it, 219, 220, 223, 234, 235, 236, 237, 238, 239, 240 through 246, 247 through 252, and 278 will also be admitted, subject to any prior orders of the court limiting those exhibits. And it's possible that at least one of those was already previously admitted, I guess.
Yes.
Okay, all right. Okay.
Okay, thank you, Your Honor. I think after that, it takes us into exhibits related to expert testimony. I believe those would be Exhibit 274, Dr. Bowley's report, 279, Dr. Weck's report, 285, Dr. Nye's report, 276, the portion that is Dr. Hammer's report, 281, Mr. Safaric's report, that we would move to admit those. I understand the state has raised a concern that they could be improperly used to bolster or vouch the experts who did testify. However, expert witnesses are allowed to rely on other information and data under Rule 703. This is something they testified they normally do in the course of offering an expert opinion. The data in 703 is not hearsay. It's also, this is a bench trial, and again, the court can afford their proper weight to these exhibits. And it goes to more than just, what Dr. Hammers and Dr. Nye testified to. It shows the prejudice of counsel's errors at the trial and provides that context for the court and the record of what is being discussed and reviewed. So even the reports don't have to be admitted for the truth of what they're saying, but it's for their use under 703.
Response on behalf of the state.
Yes, Your Honor. As the court knows, we have always objected to the inclusion of especially of the reports and information present in this case from non-testifying experts. Those reports are being offered, in our opinion, either for a vouching purpose or for the truth of the matter asserted, and therefore are hearsay that would be impermissible for inclusion of the record here. But for the use of those reports, subject to the state's objection, we have no issue with the court taking it under advisement if they would like to evaluate it, given that prior discussions have occurred for instance, of Dr. Nye's first report as a mere report of vouching to the credibility determinations of Dr. Bowley or Boley, who did not testify here. In subject to our hearsay objection, I don't think there's any way around considering them for their truth value. So we would ask that they remain to be excluded in subject to the court's determination, but no further arguments necessary on these because we've maintained our objections from the very beginning and before we came to trial.
The expert reports will be admitted subject to those objections, and my final order will clarify, I guess, to what extent, if at all, the court considers the opinions of the experts. Well, and let me clarify. I'm going to defer my determination of admission of the expert reports, and my final order will indicate to you what is admitted, because I do need to review those in more detail to determine if I can separate out any portion of the report that should not be admitted. And primarily that deals with the information from Boley. Under the case law and under the rule, it really is the Boley report that is problematic. I don't think that there is any way of interpreting the inclusion of Boley's report in Dr. Nye's report, for example, as anything other than a conduit for getting Boley's opinion in when it otherwise wouldn't come in. And that is not permissible under our rules and under our case law. And so I think it can be excised in all likelihood without damaging or taking away that portion of the work that Dr. Nye did, certainly from her second report. But I will clarify for the parties in a written ruling that in fact that is what I have done. And so with regard to the experts, that will be the plan that we follow with those reports.
Can I get clarity on just which exhibit numbers? I was a little slow in writing them down. I apologize.
Sure. So Boley, I believe, is, her separate report is identified as 274. Let me just double check my numbers here. Yeah, 274. WEC is 279. Nye is 285. Hammers is 276. And Safaric is 281.
And then, Your Honor, my friends in appeals would be remiss if I didn't ask to do this. But regarding the jail call that was submitted for the offer of proof, if I can read the name of that file into the record, just so everyone is clear going forward what we were talking about, if there's no objection.
Go ahead.
My records show it is called 687-308-34 underscore 392-804 underscore 09-22-2019 underscore 08-12-58. And there's more to it, but I believe that should be sufficient to identify.
Thank you for that. I'm sure that'll be helpful for the court too in locating the particular call to the extent I would need to. So. Okay. Ms. Nichols-Cook, anything else that you wish to address with regard to exhibits?
Your Honor, I know that we all agree the underlying record is a part of this proceeding. I think we've realized we did not file the motion for new trial sentencing transcript from September 4th, 2020. And we would like that to be a part, of course, of the record. And if there's no objection, we can upload that today. And it would be like 978, I think.
Any objection to that, counsel?
No, Your Honor, it's already part of the record. If it's easier to have it filed here, no objection.
It doesn't make any difference to me. I mean, if you wish to have it marked as a separate exhibit in this file, that's fine. But certainly by statute, the underlying case file would be considered part of this record. So it's up to you, counsel, if you wish to have it marked separately.
I think so, Your Honor.
Okay.
Just for clarity, what's 977?
An email that the fire home was shown. Right. Okay.
So it's not, but it was just no purpose.
So 978 was the number you said you would use for that? Okay, and that will be admitted.
Your Honor, the next thing on my list is to address the photographs that were submitted as exhibits. Obviously, we did not show or utilize every photograph that had been proposed. And I think that we can identify a handful of them that we know were shown to witnesses that we believe should be a part of the record, but we also don't oppose the admission of additional photographs or the group exhibit in its entirety, if that's what the court would like.
So I show, for example, 500 through 580 as having been admitted, which I believe are all photos. And I know that we didn't, or the witness didn't talk specifically about all of those, but I do show that they've been admitted. Also 600 through 655, which I believe are all photos. And again, I know they weren't all specifically referenced, but I do show that they were admitted.
I believe
700 through 734 are DCI photographs. We would have no objection to those. I believe only 731 has been admitted thus far, but for what it's worth, we would not object to the 700 series.
Okay. Did you wish to offer those then at this time?
We would offer those then.
Okay. All right, so 700 through 734 will be admitted. I know, I think there are probably some other photos sprinkled in through there, but those are the big groups that catch my eye.
Your Honor, I had 3 in the 900 series that related to Dr. Nye's testimony, and I'm happy to just identify those 3 for the record if that works.
I show 929 and 938 as being admitted.
Okay.
976, I think we were arguing about.
And I think for clarity, the photos are 800 through 975. So the third one that I have down is 890.
And I show 890 as being admitted.
And we're not seeking the admission of the rest of the Dr. Nye photos. With counsel, we would move to admit Exhibit 976 related to Dr. Nye's additional records, with the understanding that these would be for the courts to assist the court in understanding the testimony and as additional offers of proof, if not directly admissible on their own.
Any response, counsel?
Yes, Your Honor. The state has, conveyed fundamental issues with the 14-page supplemental information that was included with Dr. Nye's testimony. Certainly, I think the parts that are worked with or were worked with during her testimony fall on pages 12 and 14. 12 being her calculation page that was referred to, and 14 being the citation page or references page. The state has no issue with the admission of pages 12 and 14. The rest is a little bit wonky, given that it is aspects or portions of other admitted exhibits, not Dr. Nye's work, but kind of like a drop document that was used for things that she'd want to refer to later. So we would object based upon hearsay in the inclusion specifically, as it wasn't in her expert reports, but would simply ask that the court accept the 14-page document subject to the state's objection and reserve ruling on it like the other expert report information specifically, given that it also includes portions of other experts' reports like Dr. Hammer's, Dr. Boley, and other outlier information or demonstratives.
Right, 976 then will be treated in the same fashion as the I guess the substantive expert reports will be. Any additional exhibit issues to address on behalf of the applicant?
Your Honor, we are awaiting a signed stipulation declaration regarding exhibits 390 through 396. There'll be two declarations from court administration to authenticate and lay the foundation for those exhibits. We would ask to be allowed to move those in upon receipt of those declarations.
Any objection to that on behalf of the state?
We don't know what the full declarations look like, so we would ask that the court allow us to defer. We don't anticipate there being any issue with the declarations, but some of the information was still kind of outstanding or highlighted within the judicial branch's declaration page.
Okay, I guess on that issue, then we technically probably just need to leave the record open to receive those.
Your Honor, we just received the signed one, so maybe if we circle back to this in 5 minutes.
Certainly, that works just fine. We'll do that.
Your Honor, I just had a couple left on my list to make a formal record on. That the applicant does seek to admit the affidavit of Carrie Piercebacher as identified as Exhibit 215, the affidavit of Jake Firehelm in 224, the affidavit of Donald Pottabaum in 379, as well as the transcript of the November 10th, 2018 911 call identified as Exhibit 294.
Response on behalf of the state.
To the extent, I do apologize that I was looking at the portions for the declarations. If my understanding is we're asked about the affidavit specifically.
Yes, of Carrie Piercebacher, Gerald Firehelm.
Mr. Pottabaum.
And then the transcript from the 911 call.
Yes, Your Honor, we would renew our objections to the admission of affidavits. I believe on Monday, the court made clear on the record with regard to Carrie Piercebacher, that affidavits wouldn't be admitted for the testimonial purposes that they've been sought for, especially for Mr. Pottabaum, for instance. We believe that testimony would be uncrossed and relatively inadmissible or misleading for the court, so it would be objected to on those grounds. We believe each one constitutes hearsay, and we already addressed, I believe, Ms. Piercebacher's affidavit, but we did allow, without objection, the admission of her report. So her affidavit was unnecessary, but we would renew our objections to the remainder of the affidavits. As for the transcript of the 911 call, our position is, as we've said previously, we object to it on a hearsay ground, specifically that the record speaks for itself. The 911 call was subject to the Court of Appeals opinion. It was subject to being played in the underlying case for the trial, and certainly the court has engaged in some portions or prior rulings in the summary judgment phase or summary disposition phase here. as it relates to those 911 calls and potential enhancements. Should the court wish to receive the certified transcript, not for its truth value, but to assist or clarify the testimony of, say, Mr. Firehelm, for instance, we have no issue with the court receiving that, subject to our objection, and that it wouldn't be considered for its truth of the matter asserted.
The the 3 affidavits that are being offered will not be admitted. Exhibit 294, I believe, is the 911 transcript, will be admitted.
I believe that is all I have, Your Honor. And then we do have a list going of demonstrative exhibits that we identified during testimony. And we would like perhaps a little time to provide that to counsel and then present them.
Yes, I guess there was a question between the parties, the best way to file those. In past cases I've seen where the court files them as court exhibits. But beyond that, we don't have any problem with making a complete record. Our friends on the appellate side will appreciate the clarity.
Yeah, I do think they need to be made a part of the record, but it is important to distinguish them from the actual exhibits. And so I'm fine calling them court exhibits or demonstratives, just so that we're careful to keep them separate. They were all, I guess, paper, which helps. But if you would like to gather those up, and you can provide them to me if you'd like before we leave here today, and I can make sure that they get into the record. That's fine.
Thank you, Your Honor.
For purposes of closings, given that the demonstratives have been referred to fairly repeatedly as the same letters that cross over with the state's exhibits, referring to them as demonstrative D or whatever would be probably the easiest way of going forward. Is that okay with the court as well?
It is, yes.
Thank you. And we'll refer to ours for purposes of the record too, with the court's permission. I think making a good record here is probably the easiest part. We refer to our exhibits as exhibits A, B, C, D, F, G, H, and I believe. But we did not admit exhibit E, and we have filed them as PCR-A, et cetera, simply because the underlying record, the other ones were unavailable. So we would ask that the court recognize or accept that while we may speak to our exhibits or the exhibits that have been admitted here as A, B, C, et cetera, that those exhibits be understood to mean PCR-A or B, et cetera.
Certainly. And I did note that in the electronic record and understood the correlation and the reason why they were labeled that way.
Sure. Thank you, Your Honor.
Anything else as far as exhibits or clarifications for the record on behalf of the applicant? Sure.
Your Honor, we have executed a stipulation that the state will file here in a moment regarding Amy Bernal. And I think Your Honor, can I verify that Exhibit 314, medical records, which I don't believe was an objection to, was admitted.
I do not show 314 as having been admitted.
I likewise do not show it as admitted. I don't believe we have an objection to them, especially considering that we stipulated on Dr. Thompson's deposition and files. However, given that it is medical information and has unredacted information as would be expected, we would ask for that to be at a heightened security level. I believe a level 1 would be adequate.
Okay. 314 will be admitted.
I don't believe I have anything else, Your Honor.
Your Honor, I'll ask it this way. And I believe there was some question about security levels on a few of the exhibits. I believe most of the problematic ones weren't offered, so it should be minimal. But I don't know if maybe additional time before they're formally admitted, if the parties can, or if Mr. Mullis's counsel already knows if there's any additional ones that might need a heightened security level.
So other than 314 that we just talked about, I can tell you that the only other one that I have a note on right now as needing a higher security level is 400.
Your Honor, I think the applicant would have no objection to any of the medical examiner photos being filed at a high security level, or Dr. Thompson's photo collection.
We have no objection with that. The 500 and 600 series photos. I do note, for whatever reason, it appears that they might not have been filed at a heightened security level in the underlying case. It's my opinion that had to have been an oversight. I don't know if that's something we can also resolve while the parties are all here, but
I think that if everyone is in agreement, I can probably address that.
Your Honor, the applicant would have no objection to increasing the security level of the photos in the criminal case. I think additionally, there's a couple of photos in the 200s that were used in depositions that have been admitted that would also require a higher security level, and perhaps the autopsy report. So like 225 through 229.
As well as the state's exhibit B, which is an autopsy report as well.
Okay, I've got notes on those. The security level will be addressed in the court's exhibit management order. I believe that that directs the parties to file any additions or corrections within 10 days or something to that effect. So certainly if the parties identify any additional changes that should be made with regard to not only the exhibits that are identified as having been admitted, but also the security levels that are established, certainly feel free to bring that to the court's attention. so that changes can be made. I know that it's easier for clerk staff and certainly less work if it can be done upfront rather than later on. So.
And I do, just as I was scrolling through this list, I do recognize there's probably going to be additional, such as 216, the EMT report has date of birth. So maybe, so we do this once, if the court would be willing to defer filing of the exhibit order so the parties have time to go through the exhibits just to identify any confidential material or attempt to.
That's certainly fine, counsel. If you'd like to confer and send me an email within the next day or two, we can wait to file that. That's not a problem at all.
Thank you.
In Your Honor, I can confirm that the stipulation filing reached between the parties has been electronically signed, but also filed for the court's review and agreement here regarding Miss Amy Burnow's testimony.
All right, thank you. And then, I guess maybe so I don't forget, I'll come back to the declaration and exhibits from court administration. I think that was 390 through 396. Has everybody had a chance to look at that, or do we need a little more time on that one?
I believe the 390 through 396 portions for the jury management questionnaires or jury-related information has all already been redacted and provided. And the state has no dispute about the admission or foundation of that testimony or those exhibits being admitted here.
Okay. So the 390 through 396 will be admitted if I don't think they were previously.
Your Honor, I'm sorry, there was one more related to the jury discussion. It's Exhibit 397. It's a U.S. Census Bureau report. We would ask the court to take judicial notice of that exhibit.
Any objection to that, counsel?
Your Honor, I don't think we have any issue with the information in that exhibit being accepted as census information or anything like that. To the extent that the court wants to take judicial notice of that information, then we have no dispute or really any issue with it being admitted as census information.
Well, yeah, and I guess I understand the request to be that I would take judicial notice of it rather than admit it as an exhibit. So I'll notice it. So
thank you, Your Honor.
Yep. I'll jump over to the state maybe for now. Any witness stipulations, exhibit issues on behalf of the state? I have not necessarily cross-referenced my list of notes as far as outstanding exhibit issues. Maybe for fear we'll discover more, but I think we've hit certainly the major things as far as exhibit reports.
I guess the only clarification, just to make sure that your list matches ours, that it's all except Exhibit E has been admitted. Then I believe we have covered everything as far as my notes reflected.
Have the parties compared notes as far as which exhibits of the applicants they think have been admitted.
No.
But we can do so when we verify our final list and information. We can either do it now, Your Honor, or we can do it at the time we do the protected information, but probably for purposes of closing, it might be easier just to do our closings and then verify that information after the fact, given the numerical changes and things like that.
I mean, it seems to me like it would be prudent just to be 100% certain that everybody's on the same page as far as what exhibits have been admitted before we leave here. I understand it's tedious and not super exciting to sit here and do that on the record, so we definitely don't need to do that, but maybe before you leave here today. And also just to make sure that my list appears to match as well, would be a good idea, because obviously there are a lot of exhibits in this case. But with that said, if you think that we have addressed all of the kind of lingering cleanup issues that we needed to, if you would like maybe a short break before closings, we could do that and then come back and wrap up.
Yes, Your Honor, the last thing I had to put on the record was that the court's order regarding summary judgment, any motion to reconsider or enlarge would be due this Friday, and the applicant would just request an extension to consider that.
The state's position.
If I recall correctly, the summary order regarding the court's positions on summary judgment said a longer order was forthcoming. Should the court be open to it as well as applicants' counsel, I believe that the state would just request the opportunity for that deadline to toll until after the court's full ruling speaks to it, so that the actual questions and issues can be responded to specifically in addressing the court's specific decisions.
Yeah. I kind of like that idea. That maybe seems to me to be the most efficient use of everybody's time. Counsel for the applicant, does that
No
work for you
objection
guys?
to that plan, Your Honor.
Okay. So we'll plan on that approach, and just to have less dates to keep track of, maybe, if nothing else. So, okay. All right.
And then one last matter, I believe the court indicated brief deadlines would be addressed. Do you want to do that now or at the end?
We can talk about that now. Do either of you have a request as far as how long you would like to submit final legal authority to the court? I think I mentioned earlier, I'm not contemplating anything extensive. And really, unless you're telling me you are wanting something more substantial, I'm contemplating a one-shot 5-page limit focusing on legal authority that you believe is on point and controlling, and any particular testimony or evidence from the depositions that wasn't on the record these last few days, because I do have extensive notes from the testimony that we've been listening to. So if there's something that you want to draw my attention to from those depositions, obviously I will read them, but if there's something that you want to highlight, you could do that within that 5-page limit. Yeah, go ahead.
It's my understanding from what the court indicated previously that the court would consider the legal briefing on these issues that we already laid out in our summary.
Absolutely, right, which is part of my rationale in suggesting a very limited final brief. Both parties have spent a significant amount of time already briefing the legal issues in this matter. All of that is in the court file. I have access to it. I've reviewed it, familiar with it. And so I don't know that rehashing all of it again is useful for anybody or a good use of your time at this point. So certainly to highlight the most critical pieces now that you know how the evidence has come in is fine. But to go much further than that, I don't think is particularly helpful. So,
Your Honor, at this point, I think my proposal, unfortunately, would be to ask for 30 days, in part because part of our team is out of the country later this month, and I just to make sure that we could get all of our thoughts together and complete that. I know 5 pages isn't that much, but
April 4th is a Friday. Otherwise, March 31st would be exactly 4 weeks from today.
I think we could probably.
Your Honor, there is a major conference that I think a number of people on applicant side are attending, that the first day of which is April 4th. And I have some professional responsibilities at that conference. I can't move, unfortunately. I don't know if it'd be possible to make this due the 8th instead.
The 8th of April.
Yes.
Yeah, okay. Does that date work for the state?
Is the court seeking simultaneously filed?
Yes, yep, just a one.
Yes, I feel that. Yes, the deadline works wonderfully.
Okay. So April 8th, 2025 by 4:30 p.m. Okay, if we plan on coming back at 3 o'clock for final arguments, 15 minutes, and a final 5-minute rebuttal.
Thank you, Your Honor.
Okay, I'll see you then.
seated.
Okay, we'll go back on the record. Ms. Thompson, you ready to proceed?
Thank you, Your Honor.
Your Honor, Todd Mullis has spoken the truth in this case from day one. He said this was an accident. He asked his attorneys to investigate it as an accident. He gave multiple consistent interviews. He testified at trial. He testified at child guardianship proceedings that are part of the record below from his motion for a new trial. He filed this PCR, a verified PCR. He provided affidavits. His belief has been consistent and has never wavered that this is an accident, that he was in no way involved, and that he wanted his counsel to pursue that issue for him. That's different from other witnesses who testified at this proceeding and whose stories have changed over time. There's nothing that Todd Mullis could have said to this court that he hasn't said before. And that's why this post-conviction hearing has been about all of the evidence that should have been presented at trial to support what he's been saying all along. The court has pointed out that this is an evidentiary hearing, that all of the evidence this court is going to consider is not evidence this court heard in court during the last 6 days. Because as we just went through, the court will have depositions, the court will have documentary evidence, the court will have other evidence from the underlying record that wasn't part of what the court heard, specifically in testimony and at this hearing. But all of that together demonstrates that Todd Mullis's trial was fundamentally unfair, that the system broke down, that he did not receive the fair trial that he deserves. And that is the outcome that Mr. Mullis is asking this court to assist with now. This court really can't think about what Mr. Mullis's claims mean without thinking about what it is that actually happened at his trial. What happened at his trial was that everyone, his own counsel, the state, told this jury that Ms. Mullis's death was a murder. His own counsel agreed in opening statements that Ms. Mullis was murdered, and that belief was allowed to be presented to the jury with zero adversarial testing. I mean, this was the quote unquote strategy that his counsel pursued at trial. Their strategy was, we're going to concede it's a murder. That's a strategy they reached on the fly, which we'll talk about in a second. And as Mr. Firehelm told this court when he testified here, Todd's going to explain it. Todd will explain all of the evidence, and that is the way that they provided counsel to him through this trial. Their strategy was Todd is going to explain the text messages. Todd is going to explain whether he knew about Ms. Mullis's affair with Mr. Frazier. Todd is going to explain the Google searches. Todd is going to explain the state of his marriage. Todd is going to explain what was happening in this argument between his wife and his mother. Todd's going to explain these hearsay statements from these witnesses. Todd is going to explain without any notice or understanding that he even needed to prepare to think about or testify about this 911 call and what he said and who was there and what he was thinking when he was frantically providing aid to his wife as she was dying. Todd's going to explain the state's circumstantial evidence that is meant to show that he was guilty. And that in effect became a trial where counsel is telling the jury, even though I told you in opening statements that Todd was wrong, believe him that he's not guilty. That is not a reasonable strategy. It's simply not a reasonable strategy. And it and all of the errors that combined cumulatively to deny him a fair trial, denied him a fair trial. There are two Sixth Amendment claims that Mr. Mullis has in this case, and they're different. We talked about these at summary judgment, but I want to talk briefly about them now. One is the Sixth Amendment claim that Todd has the right to be the master of his own defense. And we spent a lot of time on that claim at this hearing, hearing from various witnesses. And I know the court has the law on this that we provided at summary judgment. The law is that Mr. Mullis has to explicitly consent in opening statements, or has to explicitly consent to his counsel conceding his guilt in the trial. He has to explicitly consent if that's the strategy. And from all of the testimony the court heard, from Mr. Firehelm, from Mr. Sabers' deposition that the court will read, from all of Todd's letters and his testimony at the child guardianship proceedings that are in the record, that simply never happened. Todd this resulted in a situation where his trial counsel conceded his guilt because he told the jury that Amy Mullis was murdered in a situation where the lawyers were going to provide no evidence to establish that that was not Todd Mullis. The evidence is undisputed that Todd Mullis didn't know his counsel was going to do that. The court has Mr. Sabers' deposition, who testified at a deposition, and the court can review this, that he was surprised at opening statements. He was surprised to hear that that was the position the defense was going to take, that Mr. Mullis was surprised. The court has all of his letters. The court has heard from Lynn White. The court will be able to review Todd's testimony in these child custody proceedings. Todd said he never gave counsel permission to do that. All of his letters support that that's not what he understood the strategy was going to be. Mr. Sabers didn't know that was going to be the strategy. That happened without his permission. And we explained already why that's important, because if that happened without his permission, then this isn't a matter of prejudice. It's not a matter of establishing what the outcome would have been if counsel followed a different strategy. That is just a Sixth Amendment violation, period. That really ends the analysis. And on that basis alone, Mr. Mullis receives a new trial. But that's not the only aspect of Sixth Amendment. That's not the only aspect of a Sixth Amendment violation that is present here. We have a more typical ineffective assistance of counsel claim too. And this is very important because in this case, there is no reason, and the court heard no reason from Mr. Firehelm, there is no reason in Mr. Sabers' deposition to explain why it would have been reasonable for trial counsel not to investigate and present evidence that corroborated everything that Mr. Mullis testified to at trial. To investigate and present evidence about medicine, about the electronic evidence, about these Google searches that we've been talking about text messages, about the cameras. There is no reasonable strategy that would have allowed counsel to not pursue any of this evidence, and instead to pursue what they did at trial, which is to concede this was a murder and to let Todd explain himself unaided to the jury. What's important about this, and what we want to make sure the court understands, is that even though in this evidentiary hearing, the applicant has spent a lot of time presenting evidence to the court and proving to the court that Mr. Mullis didn't agree with counsel's strategy, even if Todd Mullis never wrote a single letter to his lawyer, even if he was maybe a person with a little less understanding about the way that biomechanics work, his instincts about what might be true, even if we had none of these letters, even if we didn't have the vast record we have here that Mr. Mullis was asking about these issues, that he wanted this to be investigated, that he was seeking investigation, that he consistently and unwaveringly believed that his wife's death was an accident, even if none of that was true, and Todd Mullis had just said to his lawyers, give me the best defense you can, I don't know what happened, but do your best. If that's all he ever said, counsel would have still been ineffective. It is not Todd Mullis's job to have told counsel what the right strategy was here. As it so happens, he did. But even if he didn't, it doesn't matter, because there's no reason not to investigate these issues. This is not dependent on what Todd Mullis agreed to or not. It is ineffective for counsel to have chosen the path that they chose. And that is because they chose it without a reasonable investigation. We cited law to the court in our summary judgment briefings, and we will cite more law. The United States versus Hinton, the United States Supreme Court has said that it is ineffective for counsel not to understand science and not to get experts in a case where expertise is required. And Your Honor, this is such a case. This was clearly a medical case. Mr. Firehelm told you, I relied on my own understanding about this. You know, I was first chair, I made these decisions. I relied on my own understanding to decide that there wasn't anything I needed to pursue there. Under Hinton, under the other law that we've cited to the court and that we will cite, that's ineffective. The state may point out when it speaks to the court that in his deposition, Mr. Sabers did describe, you know, as the second chair, as the person who was not making decisions in this case, some of the things that he tried to do, because he did try to do more than Mr. Firehelm did. For instance, he himself went to the shed. He looked at these augers and he talked about that in his deposition. He also read the case materials like Mr. Firehelm did. But there's no evidence that Mr. Sabers discussed these issues with Mr. Firehelm other than telling him that he'd visited the shed and looked at these augers. And there's no evidence that Mr. Firehelm did anything that Mr. Sabers asked him to do. The state's own exhibits show this, that there is a email from Mr. Sabers to Mr. Firehelm where they discuss we probably should get an expert. I mean, they knew that Todd was asking them to do that. They agreed they probably should get an expert, and that just didn't happen here. They never provided case materials to an expert, either a pathologist or a biomechanical expert, who could explain to them that there was a defense here, a reasonable defense that they should have followed. They just didn't do that. And Mr. Sabers, doing his best to look at a couple of things, to give advice to Mr. Firehelm that he never followed, that's not a strategy, that's not a decision, that's failing to do what you know you should do. And there's no reason that the state is going to be able to articulate for not following the only reasonable strategy here. That leaves us with the question of what this trial would have been, the prejudice issue of Strickland, if Todd Mullis hadn't been standing alone at his trial without any of the assistance that his counsel was supposed to provide him. If his lawyer wasn't just saying, you know, trust Todd, what would the jury have heard? And at the end of this hearing, especially hearing the evidence the court's heard here in court, considering the other materials as well, the court knows the answer to that. The court knows that if this had been a fair trial with effective assistance, this jury would have heard that this was not a murder. And it would have heard that from sources that are far more credible than the state's witness who testified at trial without any cross-examination, save one question, that this was a murder. This was a medical case. And the court heard extensively, and I know we spent a lot of the court's time making sure that the court could hear the opinions of Dr. Cruz, the opinions of Dr. Hammers, the opinions of Dr. Nye, to decide what the true state of the medicine is. And based on that testimony, there's really no question what the state of the medicine is. This is not a murder. This is not a homicide. This is an accident. Dr. Hammers was able to talk about that from a pathology perspective and explain why, despite there being unopposed testimony offered at trial that Ms. Mullis had defensive wounds, that there was nothing about the state of her body or this autopsy that indicated that she was the victim of a homicide, but that this was an accident from a pathology perspective. The court knows that Dr. Cruz said that she couldn't really figure out how this happened. She just couldn't see any reason that it was an accident. And that is essentially why she determined this was a murder. After, 2 to 3 hours of doing this autopsy with other autopsies, she came to that decision, she stuck with it, and she made that decision without the benefit of any biomechanical testimony, any biomechanical advice or assistance. The court has that assistance now from Dr. Nye. Dr. Nye started looking at this case to review the opinions of others. And we're not asking the court to even consider that piece of what she did, because she then went on to do her own investigation. She did her own visit to this scene. She did her own consideration of the wound pattern. She did her own force calculations. The court has her math on her notes where she went through and actually figured this out, figured out the force that would have been required to fall from a standing height, from a kneeling height, figured out the force that would have been required and the direction of the force that would have been required for this to have happened in different ways. And from that biomechanical evaluation, she told the court that the only hypothesis that she can't disprove is that this was an accident. And there is no other biomechanical evidence before this court. If the state wanted to call a biomechanical engineer or really any witness to say that Dr. Nye was wrong, they could have done that. That's not what they did. Dr. Nye testified without any opposition. Dr. Cruz said, I really can't speak to those issues. And that's testimony the court has to consider in deciding what the state of the evidence is here. I'll go through the other evidence the court heard briefly because the medical evidence is the most important. The court heard that despite at trial, the unrebutted testimony, save for from Mr. Mullis, was that all these searches were from the iPad and that they were very nefarious. And when the court actually gets a chance to see that those searches didn't come from the iPad, that many of them came from other devices, and the actual content of the search, that these searches are related to hunting tests, they're related to television programs. The actual content of the searches and the evidence that they didn't come from the iPad tells you that Todd's testimony was right. The court will have a chance to look at all of these texts and emails, which are in evidence, and the court heard from Mr. Safarik and others about what all of this electronic evidence means. And it proves what Todd said, which is that even though his wife was having an affair, this had not bled over into the marriage, that he didn't know about it, that they were living relatively happily, despite the fact that there were sometimes, disputes with a mother-in-law. None of this was creating this situation that resulted in some planning to end someone's wife's life. I mean, there are text messages with Todd right up until the end of Miss Mullis's life where she's saying, I love you. The court has Tristan's testimony and it should evaluate it, that Tristan has explained why he testified as he did, and that his dad was really only out of his sight for a short time. The court knows about the 911 call. It heard a lot about that, about the discovery violation that occurred there, and that this was a trial by ambush with respect to this 911 call, and that 911 call is not what the state described, and that Todd was with other people, sheriffs, when that happened. There's a lot of other claims that counsel presented, and the court knows what the evidence about that is. Based on the evidence the court has, it knows that Todd's established his Sixth Amendment claims. It knows he's established an actual innocence claim, and that this is the rare case where, considering these claims separately or cumulatively, that a new trial is really the only fair outcome. I'm going to come back and talk in rebuttal in a minute, but based on what the court's heard, there's no doubt that Mr. Mullis's trial was unfair, and there's just one result from that, Your Honor, which is a new trial.
Thank you, Ms. Thompson. Closing argument on behalf of the state.
Thank you, Your Honor. May it please the court. Good afternoon. I will be brief. The state submits that Mr. Mullis has not met his burden of proof on any of his claims. We ask the court to deny his application in its entirety. In addition to the record and issues that have already been developed at trial and before it in this proceeding, we will address our legal reasoning for why each of his claims fail in our written brief. Thank you.
Thank you, counsel. Your final rebuttal.
I just want to add one more thing, which is that although we believe that we've established Mr. Mullis's actual innocence, which means that there should not be any new trial, if the state concludes that they want to rely on Dr. Cruz and retry him, that's an opportunity that he should have an opportunity to present this evidence to the jury. Because the last thing I'll say about this is the court may conclude, in looking at all of the evidence, both what it heard here, what it reads in the record, and it may determine, well, I see some evidence on the other side. You know, I see some evidence still that for me, I don't know what to make of that. I see that the state made some arguments at the original trial, and for me, I don't know where I end up on actual innocence. The court can have questions as a result of this hearing about what happened, but as the court knows, those questions are the province of the jury. It is for the jury to decide if it believes Mr. Mullis. It's for the jury to decide if it believes this other evidence. But this is all evidence that the jury should hear. Because Mr. Mullis is established, there is at least a reasonable likelihood that the outcome of this trial would have been different. With the overwhelming evidence that the court has seen, that it has read and will read, that it's heard, this is evidence of an innocent man. This is evidence of a man that deserves a new trial, and a trial where he can have his day in court. And for that reason, Your Honor, we're asking the court to grant Mr. Mullis a new trial, and we'll provide additional legal briefing in the post-trial briefing that we make in a month, Your Honor. Thank you.
Thank you, counsel. I will await both parties' final briefing by the April date that we previously discussed. At that point, I will consider the matter finally submitted. Counsel, if you maybe just want to touch base with me briefly in chambers before you leave so that we can make sure that everybody is on the same page as far as the exhibits that were admitted. And then I'll give you a day or two just to review any final security level issues before I file the exhibit management order. Other than that, anything that we need to address before we go off the record? Anything on behalf of the applicant?
No, Your Honor.
Okay. Anything on behalf of the state?
No, Your Honor.
All right. Thank you all for appearing and for your cooperation to keep things moving throughout the trial these past days. Thank you.